Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati Anglican po rin, Verbus Latino.
Is that correct?
I didn't ask you to interrupt me from stage.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Here's a little, it's doing its own thing today. It just does what it does. Good afternoon. Hope you had a wonderful lunch. I did. Sort of. I had to run downtown and pay my utility bill, which was just shy of $1,000. And if that doesn't just chap my hide, I don't know what does. That's a lot of water and power and sewer. Especially for the middle of winter. All right. Welcome. Where are we? Oh, here we are. It's good to be back. I was going to tell you, sounds like a lot. Do you do something that uses a lot of electricity? Maybe a little bit. No, it's mostly water, actually. It's mostly water that's the biggest part of our bill, which is crazy. They think they've raised our rates to pay for all the rainwater that they've been treating that runs into the sewer system. Yes, when it rains from the sky down into the street, runs into the sewer drain, runs to the sewer treatment plant, we then treat the water as if it had been flushed out of somebody's toilet, and that is so expensive that they raise our rates. So, small town things, gotta love it. Yeah. 1K doesn't cover my electric bill. California's expensive. Whew. That's a lot. That's a lot. I don't have a leak. I don't know how many gallons we use. We're good. We actually changed. We had a leak before. There was a month where I had, what was it? 46,000 gallons of water used in a month, which is just for the, you know, when you drive behind those trucks that fill up the fuel at the gas station, it was more than one of those full. That's a lot of water. That was a lot. We're not seeing the chats here highlighting. How about now? Fix it. Thank you, Knight. By the way, Knight, congrats, since you're mentioning this. First in chat this afternoon. Congratulations. Yes, you thought you were second, but no, you were first. I checked the records. Because of that, we are sentencing you to internet ownership. Everything IP-related worldwide, including my power bill, is your responsibility. Knight, congratulations. This is going to go on your permanent record. You can also go to our shopping page on the channel and scroll around until you find the internet ownership certificate there for the low fine. For the fee of 50 cents, you can pay that fine, and you can download your own copy of your internet ownership certificate, forever memorializing this occasion. The certificate comes pre-signed by myself and my boss, Mrs. R.A., and all you have to do is fill in the blank with your name. That certificate is suitable for framing or use as a cover sheet on your CV. All right, congratulations, and keep us all happy. Hey, Connor, good to have you here. Welcome, Connor. I got my Lego set. You can't quite see it, but I got my Lego set, and I'm excited. I'm excited for the build, and I'm excited to see what you build as well. So we'll see how things go. I'm a little intimidated though, because I went with a set that has over 1,000 pieces, and I'm not a master builder when it comes to Legos. Is there a stream for Corey Richards today? I haven't seen it. If there is, I'd love to see it. I think it was at KUTV2 News out of Salt Lake City was the pool feed on that trial. I've been there a couple times. worked with KTB2, but have not heard today if they're going to live stream it or if they're just canning it for later use. Got 4 boxes. Don't know which one to build. I'm debating. All over 1,000. Okay. Well, I was thinking like 500 pieces was probably my limit, but then I bought one that was big. So, any news on KR? We've got 2 KRs. First of all, there is a little bit of news. Oops, sorry. I shouldn't play that loud in your ear while I'm doing that. Let's go here. Okay. There is a tiny bit of news because something happened right as we went to lunch. They did come back really briefly. I did tell you I was going to cover that for you so you could hear what happened. So let's do that first before we jump to anything else. So here's what happened just moments ago. We're unmuted.
What is back in session? You may be seated.
Okay. So where do we stand? If there was something you all were talking about, is there anything that concerns me?
Not at all, Your Honor. I think the schedule that the court had just articulated is the schedule that we'll follow. Mr. Brennan and I have discussed it briefly. The motion to dismiss, Ms. Little's motion, which I can't remember the name of it. The motion for reconsideration, thank you. And the Downward Wolf motion.
Downward Wolf. It's like Downward Dog, only different.
All those in together.
So we will impact them.
Done.
Right,
yes.
so Mr. Alessi, are you arguing the Daubert motion?
I'm arguing the Daubert motion, and I will compact it as Your Honor has just directed.
So let's finish all this tomorrow.
Understood. Thank you, Your Honor.
All right. All right. So I'll see you all tomorrow.
Thank you.
All rise for the court, please.
What happens here? Listen carefully. Ow! Oh, so sorry. I'm not sure who elbowed who as they were fighting for their way out the door, but somebody got elbowed. So anyway, that's all that happened. So the KR stuff is on for tomorrow as the judge had spelled out, and nothing else is really her concern. So the lawyers, and they'll work it out betwixt themselves. All right. Let's see. It's puppy pose. Yes, downward wolf is what he said. The downward wolf motion. I'm not a yoga expert, but I thought it was downward dog. Not sure. All right, we have another little case that's coming up in the middle of March, and yesterday, I think it was yesterday. Yes, yesterday was Monday. Today is Tuesday. Thanks for reminding me. I did correct the live stream title. Yesterday they had motions in limine, or motions in lemonade, as some of you call them. And we're going to listen to that. This is at Josh's recommendation, so if you don't like it, blame him. Just kidding. Josh is amazing. We're going to listen to that, just get an idea for what's coming up. This is a case, this is a courtroom we love to follow. We love to jump to. This is Thurston County, Washington. Tumwater Troy's home stomping ground, and a few others. A few of you are from that neck of the woods up around Olympia. And this little courtroom has brought us so much entertainment and fun. We're going to jump there now as we hear just a little bit of motions in limine. These are the motions that are made before the court prior to court beginning, and they're basically laying the ground rules for how the teams are going to play, what they are going to be allowed to do, what they aren't going to be allowed to do, what is going to be allowed to be brought in front of the jury, and what is not prior to the trial. And sometimes it's really, really fun. So let's do that here now. Hello, Judge. It's actually a commissioner, but...
Good morning, Your Honor. Albert Dick on behalf of Ms. Morrow, who's seated out of custody to my right. And Mr. Didcock.
Yes, so we're here before the court today requesting the continuance. The background here is I believe we in fact began trial at the last hearing. We took motions in limine. I think Washington law is very clear that's the beginning of trial. We then recessed because the state wanted some more time to review some evidence that was produced prior to the trial date. We recessed to this date. Unfortunately, Ms. Morrow intends to call 2 other witnesses. If only one was unavailable, we'd have looked to proceed, but both have told me they're unavailable for this trial date. We need more time in order to bring those witnesses before the court. I believe they're material in that they confirm Ms. Morrow's statement, and unlike Ms. Morrow, who I think jurors can easily determine the bias of an accused to not be convicted, these would be people without that bias who provide the same version of events that Ms. Morrow is going to provide. So
They were in the car with her.
Right, correct.
And the difficulty getting them to come to court now is what?
Well, I think in part it simply is because they were ready for the last time. I wasn't able to confirm with them this new date. We discussed that at the last time that there's possible there could be witness issues. I talked to them about this time. They've indicated they'd be unavailable to appear tomorrow. I need some more time to subpoena them for another date and to,
Do you know of any other obstacles they have in appearing?
I don't know of any obstacles right now.
So if we reset it for 2 weeks.
Let me just check my calendar, but that sounds like something we could do. Yes, we could do the 17th.
And Mr. Lindgren, it looks like this is your case, am I right?
That is correct, Your Honor.
And the state get, looks like Sheriff Sanders here in 2 weeks?
I'm not sure yet. I'll need to discuss that with Sheriff Sanders. I learned just over the weekend that this would possibly be set out, and so I'll check with Sheriff Sanders to see if he's available at that date. If not, then I'll let the court know as soon as I find out.
Okay, but right now you're not aware of any, he hasn't told you, okay, I'm unavailable. So,
not aware of any, no.
Okay. So I think what we'll do is we'll consider calendar here.
Got quiet all of a sudden.
All right. We'll reset it for trial on the 17th and 18th of March. If you'll check this week and let us know if there's an issue with your witness and get back to us. And I'll assume, let me put it this way, I'll assume if we haven't heard by Friday that there's an issue, then this matter will be going to trial on the 17th and 18th.
Very well, Your Honor.
Okay. And you're good with that, Mr. Ditka?
Yeah.
Okay. And Ms. Morrall will give you, so we're not going to have any further confirmation. I'm just going to give you new dates. And 17th will be for jury selection and the trial will be the 18th.
Reckless driving by racing is the trial we're coming for. We should place bets now as to what kind of vehicle we think it was. I'm going with a Honda. A souped up Honda Accord. Oh no, Civic. Honda Civic is going to be my bet. Honda Civic.
Spent a good part of my weekend reviewing the pleadings submitted by the defense in this case. It's my intent to address all those issues today, so we are ready to go on the 17th.
He's about to walk out.
So I kind of felt we addressed essentially everything at our last time with another.
Okay.
Because I'm happy to address it today as well.
Okay. Well, then I'll need clarification on that because it looked to me that there had been a motion for discovery which had been addressed, but I wasn't aware of anything else that had been addressed. So
sure. So it was a slightly strange procedural way where basically we went through essentially all the motions in limine, and then at the end of the motions in limine, the state made an additional oral motion to either suppress evidence provided by the state. That was denied, but the group suggestion from the court was, but if you need more time, you can have it. And the state said, we need more time. So
Okay. Well, let's figure out where we are.
Have a seat, Mr. Attorney. Looks like we're going to be here for a little bit. You thought you were going to get a break, but he was literally grabbing his coat to leave. And the judge is like, by the way, we're going to do a little more business here today.
Ms. Morrow and I are happy to address these issues.
Yeah,
certainly, I don't think you're bound by whatever decision was made previously anyway. So,
right. I would like to clean up as much as we can prior to the trial date, so we are ready to go when trial comes around.
It's a new defense lawyer. We have not seen him before. Now shopping for a backup Lego kit.
First of all, reviewing the docket text, I didn't see that there was an order accepting the state's motion to amend. So the state, as noted in the defense pleadings, has filed an amended complaint reflecting a proper statutory citation. For the record, Mr. Ditkock, any objection to the state's motion to amend?
No objection.
Grant state's motion to amend the complaint, the amended complaint that the state has filed. State submitted motions in limine, and then the defense submitted a response to the state's motions in limine. And one of the discussions raised, the state had made the most, and by my count, the state's motions in limine were just standard motions in limine. They were not case specific. They're ones the prosecutor typically files in every criminal case. And one of them being no discussion about the possible punishment that could be imposed in case of a law violation being found. And Mr. Ditkock raises the issue of, well, if the other driver in this case shows up, he would like to, and is acknowledging that he has been offered some sort of deal to testify, then Mr. Ditkock would like to examine the terms of that deal, which would, of course, be fair.
If the other driver shows up, I want to hear him.
And you can clear this up, Mr. Lindgren. Are you expecting the other driver to appear? And if so, is that driver, has he been the beneficiary of any plea deal?
The driver was the beneficiary of a plea deal, but at this point, Your Honor, I don't expect that he will be appearing. We have subpoenaed him as a witness, but at this point, we're not confident that he will be appearing as a witness. And so just with full candor to the court and to Mr. Ditkock.
We have subpoenaed, we don't expect.
Okay, but if he is to appear, he was subject to a plea deal.
He was, yes.
So for purposes of the plea deal, you would be authorized to cross-examine him if he does testify as to any potential bias he may have for receiving some benefit for his testimony.
Okay.
That's the other driver. And, I think he's going to no-show.
There was... Sure, I cover them all.
I don't know why the defense attorney just stays standing the whole time. Thinking it's a Toyota Supra. Phil, you would probably be the best person to ask. What is the best car for street racing?
Sheriff Sanders remains at council table with Mr. Lindgren. The court typically allows that. Mr. Ditkock made his arguments. Sheriff Sanders is a witness to the matter since he was the one who stopped Ms. Morrill, and that he should be treated like the defense witnesses who hopefully will show up after being subpoenaed.
Bunch of no-shows.
The court will allow Sheriff Sanders to remain at council table. I've noted the defense objection to that, but I will allow Sheriff Sanders to remain.
So the sheriff's coming in? Nice. Hang on, I've got a no caller ID phone call. I need to pause this. It might be a prank call. We need this one. Hello? Hang on 1 second. Let me plug in my phone. Hello? Can you hear me?
Yes, sir.
All right. Sorry, I couldn't hear you there.
Okay. I'm calling back. You spoke to the young lady just a little bit ago on the wood.
I'm trying to
Your
remember.
wood magazine?
Oh, okay.
Yes, sir. So you're over there at 5179 South, 1150 West, Ogden, Utah, 84405.
That's where the magazine goes, the mail.
Okay. And they are giving you our senior citizens rate, and you don't sound like no senior, but that's the rate she's giving you.
Yeah, I always say I get the senior citizen discount, and they usually give it to me, but I'm only 30.
Okay. And then, as always with our specials, I just need some form of payment, whether it be a credit or a debit. Looks like a Visa's been used in the past.
Oh, she told me that you were going to send the bill, but then I just ignore it. And just
that's the bill. The bill that went out is what she's wanting you to ignore because it went out at a much higher rate. What we're going to do is the lower rate today, and we're going to make it a permanent rate for you.
How much is the lower rate?
We're giving it to you right here at the $34.99 a year.
34.
Yeah.
Just wondering. I have some problems with my memory because of an accident. It was actually a wood accident. It's a funny story if I can tell you because I used to have a shop.
Well, it's not funny if it affected your memory.
Well, I can laugh about it now because it doesn't hurt anymore. But anyway, I invited a bunch of friends over. I had a big shop. We were doing a wood party, and we're stacking. You ever done wood stacks? Do you know what a wood stack is?
No, I've done Jenga, but
It's
Jenga,
like
I guess,
that.
is
It's
kind of
that.
like it.
So the winner of wood stacks is called Wood Daddy Stacks, and so you're trying to be the winner of the wood stacking contest. And anyway, I was climbing on top of it. Might have been doing a little bit of drinking, nothing bad, but just like sugar, Kool-Aid, stuff like that. So we're out in the garage, we're all working, and I stack it up, and I fall, and I land, and I hit my head just smack dab right on a lathe. You know what a lathe is? Oh, it's the thing that you put the wood in and it spins it, and they use tools to shape it. It's in the wood. Do you get the wood magazine?
No, I don't.
Oh, I was gonna say I think it was November's issue of last year. They had a special on the exact lathe that I use. It's
my goodness.
But yeah, anyway, I forgot. What was the question again?
It was all I need is either a credit card or a debit card to finish up the order. But yeah, you sound like you're doing pretty good. I mean, you sound like you're doing very good, sir. I hope you continue to get the rest of your memory back and stuff. You sound like you're doing great to me.
Well, I'm sorry. What did I order? I have this problem all the time.
This is wood. It's Wood Magazine. You just spoke to the young lady about the renewal.
Oh, you called me a minute ago?
Yes, sir, I did.
Okay.
Oh, no, I'm not the one. There was a young lady that spoke to you first, and then I'm the one calling back from the processing department.
Oh, okay. And it's to pay for the magazines I got already?
It's to pay for the Wood Magazine, yes, sir.
Okay. She told me not to pay the bill.
The bill that went out through the mail is a higher rate. The computer's the one that generates those billings. They are a higher rate. We're giving you a cheaper rate, okay?
Okay. But I don't pay that one either?
No, not the bill that comes through the mail, no.
Okay.
There's other companies that will send them out as well.
Just mail it to me then, and then we'll be all good, right?
Well, no, because we're giving you the cheaper rate today. And so we're going to give you a rate that's cheaper, and we're going to make it a permanent rate for you. If we have something cheaper along the line as time goes by, we'll give it to you cheaper than the $39.99. But as it stands, you're going to get that low rate.
What if you billed me at the higher rate and you just mail it to me, and then she said I just don't pay it?
Well, the higher rate's on its way now. Yeah, the higher rate's on its way now, and when you do get it, you're going to toss it out.
I am.
We don't want you paying a higher rate.
I don't know. My family tells me I'm not supposed to buy anything.
They tell you you're not supposed to. Does somebody else handle your billings or something?
What do you mean? That the bills come in the mail.
Right.
I
You
get
said
the mail.
your family tells you not to buy anything?
Yeah.
Okay, but does somebody else handle your billings is what I'm asking.
I don't know who that would be. I don't pay any of them. I just throw them away.
Okay, so when your light bill, internet, cable, your cell phone, and all that stuff comes in, you pay your own bills, right?
I just throw them away.
You throw all your bills away, sir?
Mm-hmm.
Okay, but how do they get paid?
I honestly, I couldn't tell you that. I don't know.
Okay. All right, so what I can do, instead of giving it to you at $39.99, I can drop this down and give it to you at $30 even if you go ahead and do this today.
Do you have change for a 50?
Change for a 50? No, I don't have change for a 50. But do you have a checkbook? I can do a check.
Oh, I usually just carry cash. Do I just put the cash in the envelope or?
No, you can't put cash in an envelope. You can't send money through the mail.
Really?
But no, sir, you can't send cash in the mail. Somebody will get it.
My grandma used to send me birthday money all the time. Is it a crime?
Oh, it's not a crime. You just got to worry about people taking it out of there, though. Yeah.
Okay. What was the magazine again?
Wood.
Wood magazine? Is it Woodworker magazine?
There's woodworker. There's family handyman. Popular woodworking.
Could I, if I was going to buy it, could I buy it and send it to somebody else? Like, could I do like a gift of the?
Yeah, of course you can. The popular woodworking.
Because I've got a friend. His name is Rob. That would probably love it. I could probably get his address and maybe just send it. Would you like put a note on it and say from Dwayne?
Yeah, we can set up a gift if you want to send it to somebody, but we would still need a form of payment. We can't send the $50 in the mail.
Okay.
Yeah, we can't do that.
You guys just want to come around and just knock on the door. Just when you knock, use like a knock that's different. Because if you just do that sounds like the police, and I don't answer that one either.
So the police usually knock with their lights and stuff, with a flashlight.
It scares.
Yeah, that'd be real loud. That'd scare me to death. Yeah.
All right, so I'll be here pretty much all day. So just come by, and you did have change for a 50, right?
No, I don't have change for a 50. If I use my money, it'll all be gone by the time I get to Utah. I'm over here or down here in Florida. That's gonna take me at least 2.5, 3 days to get there, and that's if I get no sleep at all.
Okay, so maybe it'd be early next week then.
Yeah, probably. I'd probably get some sleep at some truck stops and stuff before I get there.
Okay. All right, sounds good. I appreciate it. I'll watch for you.
Yeah, sir. You don't have a credit card or debit card you can use to put this wood magazine on?
I have one.
Yeah. And no one else is in charge of your accounts or anything, sir?
Like they take my mail or?
No. Whenever a bill comes in there, you handle your own billings, correct?
I get it. I grab it out of the mailbox and I bring it in and I throw it away. I have a special, my nurse has a box that I put all my mail in. It's for garbage, and then she throws it out for me.
She throws it out for you. Okay. Well, who reads it whenever it's a bill? Who reads it and lays it over to the side to pay it?
Hopefully nobody. That's my mail.
Oh, yeah, that is your mail. All right, sir. Well, I'm going to let you go. It's been a pleasure, okay?
Hey, I have to tell you, I think you've got the wrong number. I'm not Dwayne. I appreciate the call, though.
You're not Dwayne?
No, and I've never had a wood magazine, and I live in North Carolina, and I get this call all the time. And we like to mess with you every single time. But you were nice playing along. I'm a YouTuber. You're live on YouTube, by the way. I've got a few people watching. But
What is it?
I mean, my YouTube channel.
I wasn't going to take advantage of you, sir. I was just trying to find out. I mean, somebody has to take care of you. And if you want your wood magazine, I have to go through the person that takes care of you. And that's why I kept asking if there's somebody. Yeah. Well, you have a wonderful day, okay?
Right,
and I wasn't
too.
coming to see you.
Yeah, I got that much. All right. Thanks a lot.
Have a good day. Bye.
Bye. She's like, what, you recorded this? I wasn't going to take advantage of you. Right. How many red flags could I put up that somebody takes care of me? I don't pay my bills. Yeah. Anyway, all right, let's go back to court, guys. This is what we came for.
State standpoint, if you believe a question has been proffered that would elicit improper testimony, you'll need to make the objection time. And we'll address it that way. Any discussion as to whether Mr. Didcock is retained or appointed, he acknowledges that's yes. I will beg to differ with you, Mr. Didcock, and how you phrase it in here. I think the appropriate defense response would be, we have no objection to that, because of course that's not an issue for us, rather than opposing the fact that the state has made the request. So state, I will grant that there will be no discussion as to whether you're appointed or hired. And I wonder what it once is. Again, number 5, the same. That's granted. There is to be no discussion about who owns the truth in this matter. And no discussion of procedural history. I believe you've made clear, Mr. Didcock, you are seeking 2 witnesses, and then you referred to 1 exhibit, and I wasn't sure what that exhibit was.
I don't know that we actually have 2 exhibits now. I filed this before the second exhibit became available, which is why we had a continuance last time. But 1 exhibit is a screenshot of a post by Sheriff Sanders, which has, I think, potential impeachment value, though some other admissible value. My friend on the other side and I are agreed as to its admission, subject to redaction. I don't have those redactions here simply because we anticipated this would be a continuance, but that's 1 exhibit. The other exhibit, which we already provided to the court, though may need to provide again, is some medical records for Ms. Morrow, which we intend would be admitted through her.
All right, I did see that in there.
A post by Sheriff Sanders.
Well, let's talk about that so that we don't have to deal with that on the trial date. I had some question about the relevance of that based on the dated history in there that basically said she had completed treatment and was fine.
Well, I guess my perspective, Your Honor, is while yes, the person said Ms. Morrow was doing well, there's a difference between doing well and no longer affected by the underlying anxiety issues which were being discussed there. So
right, but then I would say, okay, before I say something, let's all hold our thought. I want to make sure I'm accurate about my memory of looking at that document.
Sure.
Just pulled up the sheriff's page, and apparently yesterday they had a high-speed chase where they used a grappler in Thurston County, Washington. Gonna see if we can watch this. Melanie, I played, yes. I talked faster than I could think. I was trying to make a long story about how I got injured in my garage. And then I tried to work in Wood Daddy Stacks into it and get Rob's name in there. But it didn't go very smoothly. I'm not happy with that one. I have to do better next time. Tech support's here. What did I miss? And that Wood magazine, they are aggressive. They really want subscribers. But she did lower the price. She took it down to $30 for a year. I hesitate to Google because things like Wood sometimes have, a double entendre. So if I'm like Good Wood Magazine or something, was suddenly you're like, whoa, how'd I get here? You don't want that.
This is a July 2022 report, and it had language that
2022?
Ms. Morrill is no longer on any medications, has been off them for some time, doing well. And then the plan was discontinue all medications, cancel follow-up appointment, wished her well. So I think the relevance of tying this document to something that happens 2.5 years later or 2 years later is, without expert testimony, is questionable. So were you intending to call the doctor in to say she still suffers from anxiety?
No, I'm not intending to call the doctor. So here's my perspective, Your Honor, on why it's relevant. I think Ms. Morrill's mental state is extremely relevant in a case like this, where fundamentally our defense is she did not drive in a willful or wanton manner.
Right, I read that.
And you've read my pleadings, which got into our theory, and Ms. Morrill's going to testify. We anticipate at least one of those two other witnesses who were in the car will testify. Ms. Morrill wasn't driving willfully or wantonly. She was driving what she believed to be a pursuing vehicle. I anticipate the state, who have one witness that we anticipate to testify, Sheriff Sanders, will argue that that's not credible for a number of reasons. One reason being, why didn't she call the police? Ms. Morrill has a slight explanation for that, but why didn't she drive to a police station? Why did she try to take it into her own hands? And I think that's an argument that especially the type of people who appear at jury duty are going to be relatively sympathetic for. They're normally older people, obviously law-abiding people, people who are unlikely to completely understand the perspective of someone like Ms. Morrill. And so it's important for them to know exactly, what Ms. Morrill's situation is. She's a young woman. She has a severe anxiety disorder. I can also tell you that it's going to be important to them to simply understand how Ms. Morrill presents on the stand. Ms. Morrill is, a sophisticated, hardworking individual, but she's going to be extremely nervous and anxious when she testifies. That's consistent with the diagnosis that's forwarded in that report. I can tell you, having spent most of my career as a lawyer prosecuting SAU cases, Mrs. Morrill is going to testify like a victim in an SAU case, and she understands herself to be the victim in this case. It's right that jurors can understand that Ms. Morrill's anxiety when she testifies is not driven by the fact that she's lying to them, the fact that she may display body language that jurors may inherently see as uncredible. It's important that we have an opportunity to explain that. I mean, I don't want to be, Ms. Morrill right now, as she sits here by me, is shaking. That's the level of anxiety she has about this process. And so while I understand the court saying this came from some time ago, Ms. Morrill is going to need to explain, one, why she acted in a way that's slightly different from what other people, the reasonable person might have done in this situation, and two, why her effect on the stand is different than what most people may expect it to be. I submit that she has, number one is clearly relevant, as is two. They're both going to be relevant to the determinations made by jurors, including, crucially important, the credibility determinations made by jurors in this case. And so it's important she be allowed to express that. While she could simply express it verbally, the fact is that, as I mentioned before when I addressed my request for a continuance, I'm sure the state's going to argue this, even if they're not. Any juror who sits there reading the instructions is going to look and say, I have to evaluate bias. The fact is that the accused is always the most biased person in the room because their bias is to avoid conviction. And so something to support her statement, it's not a lot, and the jury can certainly take it for what it is, something that says, well, she's doing better, this is in full remission. We're not going to ask them to pretend to ignore that part, and I expect the state will argue that when it comes to weight. But to prevent her from, one, explaining why she may have acted in a way that isn't totally reasonable to what jurors would understand, but is specifically true for how someone in Ms. Morrill's place would act, would really fundamentally deny her an important defense. And then two, not allowing her to explain what's just going to be an apparent demeanor when she testifies, which could have substantial effects on how jurors consider her testimony, would be extremely dangerous to Ms. Morrow's position. So I'm asking that that be admitted. If the state were to enter some sort of stipulation that Ms. Morrow has this condition, that would be different, but I'm assuming they're not going to do that.
Okay. Mr. Lingren, what was the state's position on the entry of this exhibit on behalf of the defense?
State's position is that the exhibit is irrelevant, Your Honor. As you've pointed out already, it is from 2022. The events underlying this case occurred in late 2024. And as you've also said, it refers to several psychiatric conditions which appeared to have been in remission as of a couple of years ago. I'm not aware of any way that they could adequately identify or authenticate this document at trial without the presence of Dr. Darby. And defense counsel refers to the jury needing to be informed about how a person with Ms. Morrill's condition would, reliably react to given situations because of that condition. That sounds like the duty of an expert to explain what those conditions are and how they would inform on a person's behavior. If defense counsel is concerned about how jurors will view Ms. Morrill, depending on what the typical juror is like, well, then that's why we have things like jury instructions and the jury selection process. It doesn't provide defendants, many of whom are very anxious to sit in that chair, the license to include irrelevant evidence that can't be authenticated. So the state's position is still that this should be excluded.
Trying to find the actual incident.
Right. And in this case, I agree with the state. Ms. Morrill is certainly capable, if she chooses to testify, indicating that she's very nervous and she suffered or had suffered from anxiety. And if she can,
there was a racing incident in September of 2024.
Believe she suffers, but
2 cars
giving
stopped.
the imprimatur of an expert testimony without the expert being here is the court. That's inappropriate in my mind, and particularly given the fact that the defense has made a huge issue about declaring Sheriff Sanders a non-expert and not allowing him to testify as an expert. I think this is just a way of avoiding having to call the doctor to come in and testify as to Ms. Morrill's medical condition, which the doctor says in the statement is no longer in effect. She's in full remission. Now, she can testify to how she's feeling today and whether she has anxiety being in a courtroom. And for that reason, I won't allow the admission of this exhibit.
Okay, the Sheriff Sanders is, I'm just diving into his Facebook. This is crazy. He posts, he's almost like a Sheriff Grady down in Florida.
I think are addressed and they are granted to the extent that they don't need an objection at the time. Some testimony is proper. So Sheriff Sanders may remain at the counsel table. We've addressed the medical exhibit being sought by the defense, which I will not admit. Apparently there's another exhibit which there will be a stipulation to for the admission of the screenshot of Sheriff Sanders.
If we can come to an agreement about the redaction, yes, sir.
So we'll talk about that on a trial date once the redact version is provided.
I want to read you some of the sheriff's posts. These are wild.
6. The first is the no restriction on time or content regarding voir dire, and I don't know if Mr. Didcock had intelligence on how I conduct trials, but I normally allow counsel 15 minutes each on voir dire. So, and anyway, that's typically what we do in these trials. Given the facts of this case, which are very basic, was Ms. Morrill speeding because she was afraid, or was she engaged in a racing behavior with somebody else? Factually, this is a fairly simple case. It doesn't require expert testimony as to what people saw. They're just going to give their version of what they saw. That being the case, at the request of the defense, I will allow increase time for voir dire, but I'll give counsel each 30 minutes as opposed to 15 minutes.
Okay.
And then there was part of that discussion.
I guess, I'm sorry, John, I said okay. I just want, in case there is a review in court, our position is we object to any limit. We understand the limit the court set in, which is why I said okay.
Yes, no, you didn't waive your objection.
Okay, I don't want to review in court, reviewing the record and saying, well, counsel said okay, he agreed to the time.
I understand that. And I will also maintain for the court the ability to sustain any objection on content of questions if the content is inappropriate for a voir dire question. So there was sort of a broad request for the ability to get, as I read it, into any content on voir dire questions, and of course that's not appropriate. There are limits to the questions that may be asked. We'll see how that goes, but we'll give each counsel, I'll double the amount that I normally would give in such a trial, 30 minutes for each counsel on that. So I remember that.
Anything else? Because I've got a couple posts I want to read from Sheriff Sanders.
Number 2 was requesting broad latitude on cross-examination of Sheriff Sanders. I'm not quite sure what's meant by broad latitude, but on that, I'll say we'll reserve that. We'll see what the questions asked by Mr. Didcock and Mr. Lindgren. If the state has objections, you'll have to raise that at the time, and we'll discuss those.
Yeah, I certainly am more than willing to agree that A and B are not really classic motions in limine and may not really be motions in limine at all, but they are law that we want to get before the court before we get into any issues related to those. So I don't have an objection to the court reserving.
All right. 3 is the defense request to exclude hearsay statements of the driver of the other vehicle and any family statements regarding Ms. Morrill's driving habits. Was the state intending to try to introduce either of those two out-of-court statements?
The evidence of Ms. Morrill's driving habits and of the the other racer in this case, the other driver.
The statements of those people.
As of now, the state has no intention to include those statements, but the state's position on out-of-court statements would be also that the court should reserve and simply rule on potential hearsay statements as they appear. But as of now, no, the state has no intention to introduce those.
Okay. So, and part of the reason why I like to do these ahead of time, and particularly since we're continuing the trial date 2 weeks, is so counsel have sort of a pretty good idea what the boundaries are for what's going to come in and not come in. I agree with Mr. Didcock on this. I don't see any legitimate basis for those hearsay statements coming in on the state's case in chief. So you cannot, when you call Sheriff Sanders, say, what did you learn about what Ms. Morrill's family told you, and what did you hear from the other officer about what the driver said? That would be inappropriate.
Mm-hmm.
If you want the other driver's testimony, he has to be here. If you want the family member, they have to be here. And Mr. Didcock is right about that. So I want to be very clear. The state cannot use Deputy Sanders to bring those statements in on the case in chief. Now that changes, of course, if Ms. Morrill testifies. Mr. Didcock indicates that she's likely to testify. If she opens the door, the state can argue that she's presenting herself in a way that's inaccurate.
Right.
And there will be a basis potentially for allowing those statements to come in. So should she choose to testify, you're an experienced attorney, Mr. Didcock, I'm sure you will have a long conversation about where she should go and shouldn't go with her statements.
Sure.
But that will be the only realm in which we would consider allowing those statements in.
Very well, Your Honor.
Okay, so essentially I've granted number 3. Number 4 is to exclude testimony, I'm assuming from Sheriff Sanders, regarding his opinion as to whether it appeared to him, I'm assuming facts here, which I don't know, but I'm assuming based on what I've read that Sheriff Sanders was in fact following and observing Ms. Morrill and made a conclusion that she was racing as opposed to fleeing.
So, Your Honor, just so I can give the clearest understanding of what I believe the testimony will be, Sergeant Sanders was observed 2 vehicles, Ms. Morrill's and the other drivers, pass by him at extreme speeds. He did tell me when I spoke with him, he saw them appear to be matching speeds. He didn't follow particularly long because essentially he immediately engaged his lights and one vehicle stopped. That was the other individual, Ms. Morrill. Again, from the defense perspective, believing that her pursuer had been apprehended, then proceeded along at the speed limit and was later stopped pretty quickly. But so he wasn't following for a substantial period of time, but he did observe the vehicles.
So it's his observation, and any testimony that results from that observation, of course, would be relevant. And
yeah, so again, you know, I think just to really lay out the defense perspective, the officer can absolutely testify, I saw these vehicles, they were driving fast. He can say they appeared to be matching speed. He can, I believe he could even say they were driving in a dangerous manner. I think he could definitely say, given my understanding of this area, the roadways, the speed they were going, they were driving in a way that was endangering other people. I think that is all legitimate testimony. What concerns the defense, and it's really important to the defense in this case, is for him to now make the next statement, which is, I determined they were racing. That to me is problematic when you have racing isn't just a statement of they were driving fast, they were matching speeds, they were driving dangerously. It's a statement of what someone's thinking. I mean, it explicitly says this person is thinking this thing, because racing is really, it's a form of intent rather than a description of what one is doing. One could be driving fast and not racing. One could be driving fast and racing. It depends on what their subjective intent is. Do they mean to go fast with the other car to see who wins in a contest, or are they simply driving fast, or are they driving fast to escape the other vehicle? And I don't believe that there's sufficient evidence in what was provided to me by Sheriff Sanders or in his reports to indicate that he was able to make a legitimate conclusion about Ms. Morrill's subjective intent at that time. He certainly, like I said, could say she was driving way too fast, driving in an area where driving at that speed was incredibly dangerous. That's all legitimate testimony. What I believe is illegitimate is that next step to say, I was able to determine based on this small period of driving I observed that she was absolutely racing and was not being chased. That requires him to make a subjective determination about what was going on in Ms. Morrill's head that he simply doesn't have the ability to make. And also, I think importantly, it basically requires him to make a statement about the credibility of Ms. Morrill and her witnesses who are going to say the exact opposite thing, which is really problematic, especially when you have a really powerful elected officer appearing in front of his constituents in a trial such as this. I would imagine he's going to be given immense credibility by the jury. I think something his position entitles him to, but doesn't entitle to him to wield in a way that fundamentally is inconsistent with the role of the jurors and Ms. Morrill's fundamental constitutional rights. And that is my concern here, is that if you place him on the stand, someone with all this sort of inherent authority to say, I reviewed this bit of driving and I made this determination as to Ms. Morrill's state of mind, that could be so overwhelmingly powerful that it essentially decides this case for the jury when there really isn't supportive evidence that, one, from his statement details how he could actually make that conclusion. It is speculative. And beyond that, it powerfully involves the actual role of the jury by saying, I determined Ms. Morrill was racing and not being chased.
All right, thank you. And Mr. Lingren, what's your view of it?
Your Honor, Sheriff Sanders' determination that Ms. Morrill was racing was based on a combination of his observations and his knowledge and his extensive experience as a police officer. It's not speculation or assumption. It was a conclusion made with a rational basis, which is based in fact, the facts of what he was seeing before his eyes. That statement is not offered as a comment on Ms. Morrill's credibility or on the credibility of the people who were in the car with her. It is based on exactly what I've said, on Sheriff Sanders' observations, his firsthand experience of that night, and what those observations told him based on his extensive experience. And so there is adequate basis for him to bring in this conclusion, and it's not an improper commentary on Ms. Morrill or any of the defense witnesses.
All right. I will note that in the pleadings submitted by the defense, defense made a significant point of saying that its prior statements, which we've excluded from the state's case in chief by the other driver and by the family member, shouldn't be a basis for any opinion shared by Sheriff Sanders, and we've already excluded that. I also added in the fact that apparently both drivers were driving fast cars, or I can't remember the phraseology used by Mr. Didcock, but something to that effect, that they racing cars. I know you didn't say that, but that wouldn't, the type of car, people can race in beaters or they can race in fast cars. Doesn't matter what the nature of the car. So I don't want Sheriff Sanders indicating anything by way of statements that influence his understanding of what he was seeing or the nature of the cars. That's not appropriate.
Do they have tail?
I disagree with Mr. Didcock on the ability to opine as to whether it appears that people were engaging in racing behavior. I think any lay witness could testify to that. You know, drive out for us here locally, Elm Highway, and watch cars race each other on a road. Every driver who is out there watching cars speed in and out, cut around each other, you know, is watching, and they would all say, yeah, it looked like those cars were racing. I think it's going to be careful. I will allow that the sheriff to opine about that, but I will direct Mr. Lindgren to advise Sheriff Sanders he's only opining. He cannot state they were racing. He can state it appeared to me they were racing, which allows then the lawyers to get into what led to that opinion. But Mr. Didcock can then say, well, but you didn't know what was going on in Ms. Morrill's head. And that gives you the opportunity to make your defense and gives you the opportunity to use the evidence that you have before you. But it is right, he cannot opine about something which is an element of the offense, that is, you know, potentially reckless driving by racing. He can say it appeared to me that they were racing, and that's fine.
The only other thing I wanted to touch on, Your Honor, there is one thing I was concerned about is him saying they were racing, and Your Honor's ruled on that. The other thing I'm concerned about is him saying this was not a chase, and I think that's even harder for him to opine on, because it's essentially impossible for someone who doesn't know what's in the minds of the two people in those cars to say, I determined this was not a chase. So I would ask that the court enter an order saying Sheriff Sanders cannot testify. I reviewed the evidence and determined this was not a chase.
Well, the same thing will apply here. Sheriff Sanders can't, it needs to be cautioned not to say things with certainty. He can say it doesn't appear that he was being chased, she was being chased. It appears to me they were racing. That's fine. He's just giving his observations as any other driver. And we'll get to that part of it here in just a moment. So I will allow him to opine about what he has seen. To not allow him to do that would make him less than any other witness on the road, which seems, it's just not something we're going to do. He can opine like anybody else would opine about what they're watching. All right, number 5 was to exclude Ms. Morrill's history, and there really isn't history except for a failure to yield ticket that I see out of City of Olympia. I'm not aware of any other history. Did the state intend to introduce any history of Ms. Morrill on its case in chief regarding speeding?
No, Your Honor.
Okay, so I will grant that motion by the defense, and still subject only to potential that she be impeached, I guess, on her ticket, if there's relevance between what is described on the ticket and what is described here. And I have no idea if those facts are accurate. That's the only way I can see that coming in at all. But basically that motion is granted. And then the final
last one
defense motion in limine was to exclude expert testimony. Clearly, Sheriff Sanders is going to testify, and I think by the nature of what I've directed the state to instruct Sheriff Sanders about, he will be testifying as any other driver. And Mr. Lingren, you had mentioned his ability to say that based on his training and experience, he saw racing as opposed to fleeing. I'm going to direct that he not do that. He can opine as any other driver on the road, as you could, as I could, as Mr. Didcock could. Whoa. And I'm pretty confident based on what we see on the roads these days, all of us have had that thought in mind upon occasion, and we can express that thought. I do agree with Mr. Didcock that it would be inappropriate for Sheriff Sanders to say, yeah, I was trained that what I saw was racing. That's going to step too far, because this is just a lay observation that he's going to make, and the case is going to rest on that. So I want counsel to be aware of that going forward.
Just for clarification in that case, could Sheriff Sanders, I mean, obviously Sheriff Sanders has dealt with a lot of racing cases in the past. Could he draw upon his experience that the driving in this case was consistent with other racing cases that he's seen?
I guess if you want the defense perspective, I think that's vouching.
Yeah, I'm going to say no. I mean, I've seen lots of racing on the roads. I can, in any particular case, I can describe why I thought it was racing. And if somebody had told me that somebody was fleeing, I could point out facts that would indicate to me why it didn't look like they were fleeing. I think Sheriff Sanders needs to come in as a lay witness in this case. So now his history here, tying some other scene that he had, because I've seen those same things. I don't think he's any different than any other driver out on the road in this particular case. There's nothing specific about it other than what he observed. So I won't allow him to get into his experience and other observations about other non-related incidents. Which also brings us then to an objection to the expert witness testimony. I won't give that in this case because I've said I want Sheriff Sanders appearing as a lay witness. He's the driver who saw it and engaged in law enforcement activity based on that. But there won't be a need for an expert witness instruction.
Understood.
Okay. I think we've addressed the bulk of the issues before the court. Mr. Lindgren, did the state have any other issues before the court?
No, Your Honor.
Mr. Didcock, anything else?
I think there's one other thing I just wanted ruling on, so it's in the record. I objected to the state's proposed jury instructions for being out of order. I have an order I would prefer them to be in. That's not a particularly meaningful objection, so that could be dealt with later. My other objection to the state's jury instructions, which I did provide pleading on, substantial argument on, was simply I object to the inclusion of the abiding belief language. I think there's other language that's much more consistent with Supreme Court precedent. You're not directed to give the abiding belief language. You can remove it. I would ask that you remove it, or if you're going to include it, to give my version of the instruction instead. I understand the court may just simply say, I'm going to rely on what's in the model instruction, but the model instruction contemplates you may not give the abiding belief language, and I'm asking you not to.
All right. And yes, I did review that. The order that the state gives on their instructions, you can trust me, won't be the order they are given, because I don't like that order either. And so I will shuffle it around in an order that I prefer. So you may object to the order I come up with, but that's okay.
Okay.
That will be the order in which we give them. At least I'm the one giving them. That will be the order in which I give. As to the abiding belief, I had this objection a lot in the past. I appreciate the research you did on that. I will give the abiding belief instruction without the amendment. So it will be the standard model instruction. Okay. Have we now cleared the decks, Mr. Didcock, with the issues you've raised?
Yes, I think that's everything.
Okay. Mr. Linger?
That's it, Your Honor.
Okay. So both counsel now have an idea how this will go forward when we get back here on the 17th and 18th.
Two-day trial.
Thank you both.
Thank you.
Thank you, Your Honor.
Thank you.
Let me give you a little insight into Thurston County, Washington, and specifically street racing. Thurston County, Washington updated their street racing policy in June of 2024. Thurston County Sheriff's Office pursuit policy updated in anticipation of June 6th law change. TCSO, Thurston County Sheriff's Office, has finalized our pursuit policy, which is set to go into effect this Thursday morning to reflect the citizen-led initiative 2113, which repealed the restrictive pursuit law. It goes without saying, TCSO will likely have one of the most aggressive policies in the state when it comes to removing dangerous drivers and criminals from our roadways. Deputies will be authorized to pursue for any violation of law and will no longer need...
Mr. Axford, good morning.
Hey, quiet, Judge. I'm talking here. And will no longer need... This is crazy. Will no longer need supervisory permission to conduct pit maneuvers at any speed, so long as considerations are made for the risk of the public and the Graham v. Connor use of force factors are satisfied. Deputies will be encouraged to pit early and often to comply with state law, which requires the pursuit be entitled to be ended as soon as practically possible. Since the restrictive pursuit experiment went into effect in 2021, Washington State has seen its roadway fatality collisions increase significantly, despite the fact that cars are safer than ever. Along with nearly every category of crime, driving behavior has deteriorated during this time, with increases in impaired driving, racing, intersection takeovers, and road rage. This policy, in alignment with state law, aims to curb this trend with the end goal of reducing the number of pursuits that actually occur through realized accountability. If you run, you'll be captured, and your car will be impounded, and regardless of whether or not it is still operational. The days of running because the law says you can are over. If you're thinking about fleeing here, make sure the unit behind you doesn't say sheriff on the side of it. That was Sheriff Sanders a couple months before this incident happened. Okay. So yeah, they basically adopted Arkansas's pit policy, which is pit early, pit often. Everyone can pit. You can pit for any offense. And I'm looking at his Facebook page, and it's just... Let's see. I think I found. See if I can find September's. Trying to find the post because he posts all over the place. April, March. Let's just go further. It was after that. See, in August he was awarded a $150,000 grant for pursuit technology. They went and bought some nets that you shoot that tangle up the car's tires and force it to stop. Let's see, September 26th. This is the sheriff posts. On my way to work this morning, and I watched a car pass another car on Rainier Road that was already going the same speed, and then a third car passed the original car going the speed limit, and the car that passed them, the third vehicle, was doing nearly double the posted speed limit of 50 miles per hour on wet pavement, and then slammed on their brakes in front of all the cars they just passed to turn into their driveway. The driver stated they were late for work. While I can empathize with that, you are no use to your employer dead, especially conducting a maneuver that saves you all of 10 seconds. It's also not worth the $553 infraction for negligent driving. Slow down, get to work alive. Also in September, vehicular pursuits. This is the sheriff out of Thurston County. It's no secret the last few weeks have been rough here in Thurston County. There are a few allegations that need to be clarified. However, as it pertains to TCSO's policy and practice towards pursuits, the first claims that TCSO has a pursue at all costs mindset. Here are our pursuit statistics from June 6, 2024, when the law changed, to the present day. 69 total fleeing vehicles, 38 pursuits terminated, 31 total suspects captured. Currently, TCSO deputies are terminating more than half the pursuits they initiate for public safety concerns. We don't discuss these terminated pursuits very often for the simple reason that we do not want criminals to understand what goes into decision-making, or they will simply invoke that specific issue every time to get away. As an example, if we created a public policy that we will stop pursuing the suspect if it hits 100 miles per hour, That becomes the new benchmark for guaranteed escape, and they will aim for 100 miles per hour every time. The second claim is that deputies aren't required to weigh the risk to the public when making a decision to pursue a vehicle. This is also untrue, as both policy and RCW rightfully set forth this requirement. Compliance with the statute and policy is enforced by a requirement that the footage from every pursuit is reviewed by a supervisor to ensure decisions being made by deputies are appropriate and within policy. While the county as a whole is experiencing issues, Washington is in a league of its own when it comes to road safety, stolen cars, and impairment. Lately, those three items have been intersecting hard and creating harm in our county and state. For instance, while the rest of the nation is trending to a 2% decline for fatal crashes, Washington continues to see a 10% annual increase in non-pursuit related road fatalities. Fun fact, in 2022, Washington, with 7.7 million people, had more cars stolen than Florida, with 22 million people, despite having 1/3 of the population. These stolen cars aren't just crucial for the victims who need transportation. They're being stolen to commit new crimes such as shoplifting, burglary, smash and grabs, homicide, robbery, and more to avoid being identified. Now that the law has changed, we are dealing with an intersection of consequences as a result of the 3 years of law, which clearly outlined that running in cars is effective to avoid capture and led to an explosion of stolen cars, a drug epidemic that has put more impaired criminals behind the wheel, and the fewest police officers per capita in the country. It would be really easy right now to order my deputies to become reactive, terminate all of our pursuits instead of most of them, and simply take crime reports over the phone while we watch from afar as deaths and crimes stack up so we can say, at least we didn't try, so we can't be blamed. A similar concept applies to active shooters. There's a risk involved by running into a classroom and confronting a shooter. You could miss and hit a child. Maybe the shooter was just about to surrender and your presence escalated them. Maybe they're waiting for you and you're killed in an ambush. We could just wait until the shooter is done and investigate later. We could respond without our lights and sirens so that we never risk crashing. None of those risks are going to stop my deputies from getting there as fast as possible, running inside and saving as many lives as they can. We are more comfortable trying to save as many people as we can and failing than never step a foot in the arena for the sake of avoiding scrutiny. Wow. Wowzers. I have to get some footage out of there. Actually, I think we've got a pit maneuver we might be able to share here. How can we do this? What, a street race against a police car? It sounds like the place to go. Thurston County makes live on patrol a lot. I might have to start requesting some video from them. Shirley sent a link to the burner phone. Let's take a look at that. We're getting there. All right. I've got a lot of links. Let's see, here's a web link. Well, that's the document lookup. Thank you very much for that. I've not been able to get that site to work well for me. That's funny. This is the sheriff's post about the incident. Okay, I think this is it. Thank you, by the way, for this link. It was on the same Facebook page. I just hadn't got there. Earlier tonight, I was driving down Carpenter Road. This is the sheriff's post. Carpenter Road Southeast, when I observed a silver Mercedes and a black Honda fly past me at 68 miles per hour in a 35 mile per hour zone. When I activated my emergency lights, I could hear them continue to accelerate. I caught up to both cars, and fortunately, a TCSO deputy was also in the area, which allowed us to stop both vehicles. The driver of the Mercedes said they didn't know who the other person was, and they were chasing them. However, the driver of the Honda stated they linked up through Snapchat and came to Lacey to race. The driver of the Mercedes said they just got the car after their last one was totaled. They'd been issued a criminal citation for racing, and Summit Towing gets to keep their car for the next 72 hours. The driver of the Honda was issued a criminal citation for racing and driving on a suspended license. Summit Towing gets to keep their car for 72 hours as well. Reckless driving in Thurston County will land you in jail in up to 364 days in jail, a fine of up to $5,000, a 72-hour impound, and a 30-day license suspension. Also, your insurance premium will likely shoot up astronomically. Better off not racing. So that might be the one. That might be the case that we're talking about here. Mercedes versus a Honda. I think our defendant is in the Mercedes because she was winning. She was in front. Let's see. Cheat code to Thurston. Oh, the weekly trial schedule. There you go. All right, she thought she was being stalked. All right, let's see. We might do a tiny bit more court hopping here today. I'm not sure what Judge Simpson's doing. Is the case that Judge Simpson has safe to watch? She's had a couple that have been pretty different. Might go down to Judge Stephanie Boyd really quickly, see what she's doing. Judge Boyd, are you there? She stepped out for a minute.
Oh, that's right. So we got everything done.
Might be time that they're just about getting close to being done. Let's see if there's anybody else who is still working out of our favorites. Judge McBurney has a criminal calendar. Let's go to Judge.
It was hard for all of them, but it was hard,
Simpson.
particularly for him, to go through that. I wanted to make that very clear on the record in terms of this court's perception of all of the victims as they testified, because I think that's important. It's important, and I'm not going to be the final decision maker on this case. That will likely rest with some jury. But what I saw with them, they need to be believed, and they ought to be believed.
I think
whether anyone does, that's maybe for the future. But I believe them. Believe everything they told this court. Having said that about the victims, I also now turn, because I think it's important to understand at least the courts.
Yeah, we're gonna bail on this one. I think I know what case they're talking about, and it is a tough one for sure. I think it involves a lot of SA. Okay, Judge Boyd, no. More Thurston, not that one. It's the protection order from Thurston. This one's they're done, not live anymore. Oh, Burnett's live.
Telephone if questions arise. The court
this
is
judge.
hereby revoking bond because these are serious felonies. We need to set a date and time for the sentencing.
This judge is phenomenal. If you go to her drug court hearings, they're incredible.
I can do May 19th, and you have your choice of morning or afternoon.
Afternoon.
Yeah, right now I have a jury trial scheduled for the 19th.
I can do June 2nd, morning or afternoon. Or June 4th, morning or afternoon.
Either of those work. Any of those work.
Any or
All
all
right,
of those.
let's do June 4th, starting at 9:30. We'll block off 9:30 to noon, just in case. Victim, will there be a victim impact statements? Yes, so that's why we'll block off 9 to noon, just in case. All right, anything further before we adjourn?
Not from me.
Mr. Keen.
Just a quick correction. In 24 CF 109, the max, it was a class I felony, so the max was 3 years and 6 months rather than also being 6 years.
Oh, sorry, thank you. That is a correction. As to the assault by a prisoner, it's a $10,000 fine up to 3.5 years of incarceration or both. The other charge was up to a $10,000 fine and up to 6 years of incarceration or both. So, Mr. Starkey, do you understand that they have two different maximum penalties?
Yes.
And I made an error before when I told you the maximum penalty for the assault by the prisoner, the throwing or expelling the bodily fluids at law enforcement. Do you understand that I made a mistake, but now I'm correcting it?
Yes.
All right, thank you. Thank you, Mr. Keen, for catching that error. Anything else you want to add?
No, Your Honor.
Thank you. Then we are adjourned.
Okay. You're at the
Thank you. Okay, now the jail is coming through.
Mr. Starkey's currently out in the Polk.
How long is he going to be in Polk?
Got a revocation hearing on the 24th of March.
He can go over there. I'm fine if he goes over there as long as he makes sure that we get him back for our sentencing. Yes, we
This
can
was the
address it
same
when
one,
we get it.
Allison. Yep. I think that's the
Sounds
last
good.
time we watched her was that case.
Maybe. Yeah, maybe stuff going back to full count. Yeah. Yep.
I honestly don't know what's going on in Polk.
Yeah, he's waiting his revocation hearing on March 24th. And I don't know.
Yeah, I represent him on that.
Do you know if he's got an imposing stay or if he'll have to go back for sentencing if he does get revoked? Or?
It would be going back for sentencing if he's revoked, and usually that takes around a month too. So realistically, they'll probably both get done around the same time.
Around the same time. Okay, thank you.
Thank you so much.
Thank you. We will go on the record. This is Mr. Den. What are you looking for?
Oh, sorry, there was just a bunch of other things.
We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. We have Glenn Keene appearing in person. Mr. Den appears by video conferencing in custody in Burnett County Jail. We're set here today for a request for a bond modification. Mr. Keene has filed a bond modification request on February 25th. Mr. Keene, please provide argument for the record.
Yes, Your Honor. As the court's well aware, before trial, there's a presumption that a defendant has a right to be out, not in custody and preemptively punished unless there's reason to believe that the defendant will not show up for court.
That's not necessarily true, and the state just has to prove that there's probable cause to believe that the crime was actually committed in order for the court to assess bail and to use other certain factors, not just making assurances that they're coming to court.
Well, right, and the other one is usually about not committing further crimes. But what I would note with Mr. Den is that he does have a record of making his prior court appearances on a lower amount of bond. He is a landowner in Burnett County. His daughter and grandson live in Burnett County. In fact, he was with them the day before he was arrested. He communicated with the court in the last case in this county in 24 FO 76. And when his other case in this county, it was more recently in 18 CF 54, he successfully appeared for all 15 court appearances and completed 9 months of jail via electronic monitoring, which obviously if you're on electronic monitoring, you can always on your own choose. It's easier to try and escape by just cutting the bracelet or other things versus if you're in the Burnett County jail here, where there's an issue of appearing. He's been in custody for, a month and a half, pretty much, is not being able to raise the $100,000 bond. And the only reason he didn't qualify for a public defender is because he did have, some property in the county. And we're requesting to lower bond to $5,000 secured by his property. And I do have a copy of the deed that I could file with the court to show.
It would have to be a quit claim deed signed over to the county.
Right, and we would do what we need to do to make that happen if it's granted. But in my motion, I do show that the only thing he's showing is owing on it is $325.55 of property taxes for the current year. But the properties are valued at $33,000 because they're together $33,400 for as far as property tax valuation.
Mr. Schmidt?
I would oppose modifying bond at all. I'm deeply concerned that if Michael Den's bail is reduced any amount, he might be able to get somebody with a lot of money to post it for him, somebody powerful he knows through his connections or his family. He's charged with a delivery, which was a controlled buy, so that's a strong evidence, and he was found with nearly 100 grams of methamphetamine. The evidence is strong in the case. The strength of the evidence is something the court considers in determining bond because that's mandated by statute. He admitted to law enforcement that he was acquiring methamphetamine in the quantities of, in his description, pounds and kilos and bringing them to Burnett County and distributing them. He said his connections are in the cities, which is where his main connection is from. He only came here from Minnesota in around 10 years ago, and he's been at that property he's describing. With his admissions and what he has there, that's strong evidence. In his interview with Deputy Megan, he expressed fear that he was going to die in custody because of these charges, which is more concern for the court that he might not come in the future.
Does he work for the mob?
It is true that he has generally made court appearances on bond, both here in Minnesota. He has not necessarily followed probation conditions. The 2018 case we had in Burnett County, for example, was while he was on probation for felon in possession of firearm out of Minnesota. He has some familiarity with the sentencing on these charges, not just from the maximum penalty. Mr. Den's twice been convicted before for crimes related to the sale of drugs. The first time he only got a year in Minnesota. The second time he got a 10-year sentence. I think he rightly fears that he might get more than 10 years, and with his age, that could wind up basically being his whole life. I think with the strength of the evidence, with his history, with his demographic information, I think the court shouldn't reduce bond. If he gets out, I don't think he's coming back. Thank you.
All right, thank you. With hearing those facts, and the court does have to weigh into whether or not the state has proven, I believe it's even beyond a probable cause, but in hearing the evidence and even in hearing the evidence that was presented in the criminal complaint, we're dealing with a delivery of methamphetamine allegation, which carries a maximum penalty of up to 12.5 years of incarceration and up to a $25,000 fine, and possession with intent to deliver methamphetamine greater than 50 grams, which is a Class C felony, which has a maximum possible penalty of up to 40 years of incarceration and up to $100,000 in bond. So that is very significant, and that is a high incentive for an individual to flee or to not make court appearances. It's not a low-level crime like a simple possession of methamphetamine, which is a maximum of 3.5 years of incarceration. Based on the arguments made, the court will deny the modification of bond.
The only thing I note on there is that D.A. Schmidt was referring to items that aren't in the complaint at all about interviews and other things.
And you can do that
Right,
in a bond
fine.
hearing. You're allowed to use hearsay in a bond hearing. If you wanted to have other witnesses, you could have witnesses
Right, but
in a bond hearing. We could have a bond modification hearing that goes 4 hours. Some states do that. Some states actually call people and put them under oath and have witnesses back and forth between the parties. Here in Wisconsin, you're allowed to use hearsay. You're allowed to make your arguments, and it would include providing information that's not in the criminal complaint.
all right. Well, like I said, I think when you look at it, you do have to at least consider his past performance as far as court appearances.
I did, but that's low-end felonies to maximum of 40 years of incarceration is what he's facing for one, maximum of 12.5 for another, and then 3.5 for the maintained drug trafficking place.
Right.
Those are two very serious felonies, one serious because it's a felony. So the court denies bond modification.
All right. I've also been, Mr. Den wishes to invoke his right to a speedy trial as well. And I filed the motion for discovery from the DA's office.
All right. So speedy, put it in writing, but we can get a trial date set. Mr. Schmidt, how many days do you think we're going to need?
Honestly,
yeah,
probably one.
Only 1 day?
It was one controlled by and then searching, playing his interview, no, 2 days.
All right. So let me see if I can figure out our new system.
You can drink some of this. Did somebody just open a bottle?
Do you have lab analyst?
I distinctly heard a decorking occur. I'm looking for a good Lego model as a backup for my existing one.
Oh, so we have to set it, and then it is a speedy, so we just okay, we'll go that route because we have to set it, and then the state has to talk to the lab to make sure that they're going to get everything ran and that we can be a number one because it is a speedy and it will go. So 90 days.
It does look like they sent it to Wausau soon after they acquired it. Police, I mean.
There's a police chase set. Oh no, that's not Lego brand. I need it to be Lego brand.
May 27th. That's a day after Memorial Day.
It's a good day.
And then we'd have 28th as well.
Oh, and well, I have to check with Mary to see if I can block 28th. Well, we don't know if that's going to be a number one, so we may have to move it, but Mary says June 2nd and 3rd works best. June 2nd and 3rd. It's a speedy, so no matter what you have, Mr. Keene, you must move it. So June 2nd and 3rd, we're setting it for a speedy trial for Mr. Den.
No matter what you have,
now let's get a final pre-trial.
That's an order from the judge. Your calendar was just cleared.
Final pre-trial, the court's drop dead date where the court will not accept any agreement after that date and time. May 8th at 9. That means.
That day I have a contested divorce hearing in Ashland County.
All right, May 7th.
Hang on, he does family
Can you
law
do
and this?
2:30, May 7th,
That's awesome.
I am checking that now, Your Honor.
or May 8th at 11:30.
The 8th I'm booked until 2 p.m. The 7th I am open, Your Honor.
All right, May 7th at 2:30. May 7th at 2:30 will be the final pretrial. Again, that is the court's drop dead date. Hopefully, we're going to be able to use the 2 days that we have set aside now for our speedy trial. The court's drop dead date means the court will not accept any offer, any agreement after that date and time. That means it will go to jury, and it will go to jury on the Class F, Class C, Class I felonies, and the Class U misdemeanor.
Getting all the letters on this one. It's got the whole alphabet. It's going to be on his rap sheet if he gets convicted.
The only way it will be removed from the calendar is if we get full pleas on all or dismissals. All right. Anything further, Mr. Schmidt?
Not for me.
Mr. Keene?
That's what happens when you ask for a speedy
All right,
trial.
then we are.
Can I ask something?
Oh.
No, you have to talk to your attorney about it.
Oh, wow.
And she kicked him out.
I'm guessing he wants to talk to you. Miss Bottleson?
That was... she just cut him right off. Wow. Oh, wow, he says.
If it's anything that the court needs to hear, you know, you need just write it, put it in writing. Thank you.
She's one of my favorite judges, and watching her in a drug court setting, you see a completely different side of her. She's right up there with Judge Simpson, with Judge Boyd. I'd even put her up there with Judge Carroll. She's amazing. She's one of my favorite judges.
Can you make sure the last statement I said to counsel is on the record, please?
She's growing on me. Can you make sure the last thing I said to counsel?
If it needs to be in writing, let the court know.
She's second thinking
to know it needs to be in writing. That's what he said.
Kicking him off the Zoom early. Ricky C just gifted 5 memberships. Thank you, Ricky. Purple Coconut. Oh boy. She needs somebody to gift her some Excedrin, I think.
Have you been in any other counties, Mr. Gramstrup, today?
No, this is actually the only thing I had today.
Oh, you haven't been to the chaos. We all had updates and everything is a mess and chaotic. I don't know my system anymore.
As to
Everything. Every
Really?
single thing. Every
You mean
application.
all the online stuff?
Even Zoom.
Polk County's next week. They haven't
Oh
experienced
my gosh,
that.
they have not
Really?
experienced it. Everything. I can't get my Zoom to function properly.
Huh.
I can't get any of my anything to
So it's the
function properly.
court system computer.
Yeah, they
court
did a
computer
total
system.
update. I can
Oh.
see my
refresh.
cases and do those
Yeah.
things,
Hmm.
but everything else is just like,
Can things be e-filed?
yes,
Okay.
all that is fine. It's just how
Just-
we view and
got it.
how we use is all different.
Oh, wow.
So we have to relearn how to use this new.
Oh, so it's not messed up. It's just
It's a
new
new
and different. So
system.
everybody's
Everything's different.
behind the 8 ball trying to.
They took away all
I
my
got it.
little applications and
I
all my
see.
little things on my taskbar.
Oh,
and
wow.
all those fun things, and it's like, oh my goodness.
I hate when I get updates on my phone. I'm lost for a week.
Exactly. And it's like trying to then have a real day, a full day of court, and you're like, how do I maneuver? What do I do?
Yeah.
Cleo, welcome. Good to have you here in chat.
We will go on the record in the matter 25 CF07, State of Wisconsin versus Ashley Bottleson. The state appears through Assistant District Attorney Holly Rockow in person. We have Christopher Gramstrup, Defense Counsel in person, along with Ms. Bottleson. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. I've been handed a plea questionnaire waiver of rights form. Mr. Gramstrup, can you please recite the agreement for the record?
Yes, Your Honor. Ms. Bottleson will first be waiving her prelim in this matter, and then she would be entering a plea of guilty to count 1. Count 2 would be dismissed and read in. There's a joint recommendation for withheld sentence, 2 years of probation, restitution in the amount of $185.15. Any programming per the DOC, usual costs, fines, fees, and DNA sample and surcharge. She has been fingerprinted, and there would be no sentence credit due.
Okay. All right. So that is the agreement that you reached with the state, Ms. Bottleson?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes.
Did your attorney go over this document with you?
Yes.
Judge, I hate to interrupt, but I think we have to waive the prelim first. She
Oh,
hasn't
that's
had a
right.
prelim.
Thank
Yeah.
you. I forgot because this is a felony and that's what we were going to do. So first, you understand what it is to have a preliminary hearing?
Yes.
Your attorney went over all of that process?
Yes.
And that means the state has the burden to prove a felony probably occurred in Burnett County and you probably committed it?
Yes.
You understand that by waiving your right to a preliminary
probably
hearing,
committed it.
you agree the state can at least meet that burden?
Yes.
Do you understand that at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses or call witnesses to testify for you? He would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today?
Yes.
Do you understand that if at the preliminary hearing, the state does not meet its burden, I could reduce the felonies to misdemeanors or dismiss them altogether, but you would be giving up that right today?
Yes.
Do you understand that as a result of waiving your right to a preliminary hearing, it means this matter could have proceeded to further proceedings, which could be a trial?
Yes.
Do you understand that once you give up the right, it's forever and you can't get it back?
Yes.
Has anyone made any threats or promises to you for you to waive your right to a preliminary
No.
hearing?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing
Yes.
and voluntarily?
Yes.
I will find you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and find the matter over. Information, Ms. Rocco.
I'm just filing it now, Your Honor. It mirrors the criminal complaint.
All right, now we're going to proceed with the plea, and the plea is to plead to count 1, dismiss and read in count 2. So at this time, I'll enter not guilties for both counts. Well, at least for count 2. And as to count 1, you wish to enter a guilty plea, is that correct?
Yes.
And so I do have this plea questionnaire waiver of rights form, and this is the document your attorney thoroughly went over with you?
Yes.
And is that your signature on the second page?
Yes, it is.
Did he go over it essentially word for word?
Yes.
And so do you understand everything on the document?
Yes.
Now, you're pleading guilty to count 1, unauthorized use of food stamps. You're 30 years old, you have 12 years of schooling, you can read, write, you understand the English language. That's all true?
Yes.
And your attorney, did he go over what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over the maximum possible penalties you face?
Yes.
You're not receiving treatment for a mental illness or disorder, and you're not taking any medications, or you've not had any drugs or alcohol?
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that these are felonies and you will no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any election until your civil rights are restored?
Yes.
You understand that here the state would have to prove on or around July. Well, I have different dates. My system says July 4th, 2024, and I have on the criminal complaint between June 18th, 19th, June 20th. What's the difference here?
I think that there was an error in the original filing with the July 4th date. The correct dates I have in my file notes, which were discussed with Mr. Gramstrop, were the 17th, so on or about June 18th.
All right. So, Ms. Bottleson, you understand that there is an error on the criminal complaint as it was filed because it states June 18th, 19th, or 20th, but it's around or about those days?
Yes.
And do you understand that the state would have to prove on or around those days in Burnett County, you as an unauthorized person knowingly obtained, possessed, transferred, or used food stamp program benefits, and the value of those benefits exceeded $100 but less than $5,000? Do you understand what the state would have to prove?
Yes.
Hang on.
Do you
This is a
understand the
food stamp
maximum
case?
possible penalty could be up to a $10,000 fine and up to 3.5 years of incarceration, or both?
Yes.
Do you also understand that there is an agreement here between the parties for a recommendation to the court for 2 years of probation with what's called a withheld sentence? Do you understand that I'm not bound to follow that recommendation?
Yes.
I could sentence you all the way up to that maximum penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Do you understand the difference between a withheld sentence and an imposed but stayed sentence?
Yes.
So I don't need to go over that with you?
No.
Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, there is that section, and it's called the probable cause section. It basically says what happened around that time and why you were charged with the crimes. Do you remember going over that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today you in fact did use, possess, or transfer food stamp benefits for your benefit?
Yes.
And it was $185.15?
Yes.
And you agreed to pay back that restitution?
Yes, I do.
All right, Mr. Gramstrup, may the court use the probable cause section of the criminal complaint along with the statement made by your client to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you what the state would have to prove and taken the facts as alleged with the elements the state would have to prove?
Yes.
Has he went over with you whether or not
we're gonna bail on this here just in
or
a
a
minute.
lack of defense?
Yes.
And are you satisfied with the
Like in
services?
3,
Yes.
Any
2.
questions for the court or for your attorney before I proceed?
No.
As to count 1, food stamp offense, unauthorized use of food stamps greater than $100 but less than $5,000, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up your rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. As to count 2, it will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Before I ask for arguments, can anyone tell me if she has a criminal history?
She's got something minor in Wisconsin, an FO, I think, but she did have a possession of meth that she successfully completed probation on in Minnesota.
Was it a
She
FAFO
completed that
or
probation November of 24. It was a 1-year probation, no violations, and it was for a very small amount, close to residue amount of meth.
All right, thank you.
Okay, I'm going to bail.
Argument, Ms. Rocco?
I'm going to bail. Sorry, we're going to bail on that one. We've got another case that Mathis has been begging me to play. And he even said a super chat begging me to play this. Now he's sending reminders. Mathis, this takes us all the way back down to Florida. So we've got a little whiplash. Let me set the stage for you. This is the 2nd District Court of Appeals. So we have 3 judges and 1 attorney. I'm going to let you, I'll just let you take a quick peek. You can guess who the 3 judges are, right? You can guess which one the attorney is. Okay. This one's going to fill itself in as we go. Okay. That's how it's going to go. We're going to listen. It's about half an hour.
We have audio.
We have video.
Don't have video yet? Not yet.
No, sir. We do not see.
There you go. Now we got it. We're done. We're ready.
There's a
See
forced
you in
laugh.
the next,
There's a
Would
forced
you like
laugh.
to reserve any time, Mr. Dandar?
5 minutes, please.
Yes, sir. You got it. Go ahead, sir.
Good morning. I'm Ken Dandar, and this is case has been a nightmare for me. I've been an attorney in Tampa Bay since 1979 and met my client Peggy Hawkins at church through our Monsignor.
Oh, Peggy.
And I represented her for many, many years. And I found out that she had 2 sons out of 3 who were drug addicts and alcoholics. And she asked me to help her take care of them. And so I did.
Well,
And
let me just get to the chase. What's going on with the accountings? You never provided the accountings for the longest time. The preliminary accounting, then no accountings thereafter.
I didn't provide an accounting. I thought her CPA, who she's had for many years, would help me provide an accounting. And when he said no, he said, that's a specialty. I had no idea who to turn to. I went to Mr. Dixon.
But you're the trustee, right?
I'm the trustee. I've never had a trust like this.
Provide the accounting.
Pardon me?
Whose duty is it to provide the proper accounting?
It's lawyers.
I am as a trustee, yes.
And then you took fees for the work you performed pursuant to a trust created in 2009 that was never funded. Is that correct?
Well, that's all. No, the 2009 trust was funded because it owned a motel and made money that way through the motel. But I never charged her for the 2009 to 2017 fees while I was incurring them to take care of her son, and then take care of her, take care of the son who was in a condominium that she bought for him when he divorced his wife.
But the trial court rejected you made those arguments below, correct?
I made these arguments below. I provided the court. I provided the lower court with a declaration that explains all the different accounts. And I also provided time records, and the court refused to look at them because I missed.
Late in providing the accounting. The trial court basically could have done what it did on that basis alone, correct? It didn't have to listen to the arguments you're making to it or making on appeal.
It didn't look at my accounting that I did because it was too late. Even though I filed it in ahead, properly timely and ahead of the motion hearing for summary judgment. And I asked the court to even let me go to the forensic accountant, Purcell, because she made so many mistakes. I said, let me sit down with her and we'll have a proper accounting done. And the trial court, or probate court below said no. And so I couldn't get Mr. Dixon to return my phone calls. They called him. I don't know what they said to him, but I couldn't get him, the CPA, to do an accounting for me. And I couldn't get the court to let me talk to Purcell and do an accounting. And I have all my time records, all the expenses. And that's why I finally filed a motion to dismiss based upon fraud on the court, because the substitute
fraud on the court
trustee, Miss Diamond, she knew that I purchased a home on a golf course for in excess of $500,000 for the daughter, the adopted daughter, Miss Wurr, the plaintiff in this case. And I bought that house for her at her request, paid cash out of the trust. And the trust was a remainder interest. She had a life estate with her husband to protect her. And Purcell, the accountant that Diamond hired, knew this. And they knew this for years before this hearing, and yet they put down on there that I'm being charged for this $500,000 home. I paid off the mortgages on Peggy Hawkins, the decedent, the settler. I paid off her mortgages on her home. I'm being charged for that. And
I had a question for you. Can I interrupt
Yes.
real quick and just clear up? And this may reveal some ignorance on my part of the record. You can clear up. So that was excluded essentially, for lack of a better term, because of the cutoff and that was imposed upon you, I think. But why didn't you assert that earlier in the litigation? Why didn't you produce that documentation earlier?
Well, I had to create the documents.
No, not created. I mean, they were just existing documents, right? There was like closing documents or something that supposedly evidenced that this was properly, that this was a proper expensive use of trust funds.
Well, that's my mistake.
Why didn't you assert that earlier?
I should have done that.
after the fact, well, look at this. Here it is. It's the smoking gun. You know, this was proper use of trust funds. But I don't understand. I just don't understand. Why didn't you said, well, I couldn't get the accountant to do X, Y, and Z. Well, why didn't you just show that to the court?
I should have done that. You were absolutely correct. It's a public record that she owns the house. And the house is in her name. That's a public record, but I should have done it.
By the way, I'm not, I just wanted to say I'm not opining on whether that is proof positive that it was a proper use of trust funds. And maybe it is, maybe it isn't. It doesn't matter to my question, but you understand that. But so you're saying what now? It was public records. Doesn't that support that it's a mysterious that you didn't assert it earlier?
I asserted it at the hearing, and I asserted it in my declaration that I filed opposing the summary judgment. And I'm asking the court to reverse the summary judgment, reverse this multi-million-dollar judgment against me, which is destroying me, and let me go back with their accountant and sit down and go through all the records, because all of it is accounted for. In my declaration, I filed at record 1310 to 1376. It shows all of my time records that I expended.
Well, what is the standard of review in this case?
Is there an issue of material fact?
Okay,
that's the standard.
And the trial court found that you didn't present any admissible evidence.
He ignored what I filed in opposing the summary judgment motion. He wouldn't even look at it. And it's a sworn declaration by me, and it's all my time records attached to it.
So you're saying that was admissible evidence?
Yes.
Even though the court said it wasn't admissible.
He wouldn't look at it. No, he just said, I'm not looking at it.
Is that because it was adduced
late
prior after the cutoff hit the court imposed?
It was after the cutoff. Yes, it was after the cutoff.
Well,
and I asked to
at
go.
one point, didn't you also testify you don't know the law on trust?
What?
I don't know. I may have, because I never had to do this before. This is my first time.
Yeah, that's probably a good reason why you shouldn't be doing this, but.
And I don't do it. She was my longtime client, and she asked me to do it, and I said, okay. She had, because of the two sons primarily.
Well, that's
she was
issue. Okay.
One tried to kill her, and he ended up hitting a cop over the head and went to jail and escaped several times. He's now in Florida. But
Dandar,
the other,
Mr. Dandar, I don't mean to demean any of that. What you've done is laudable, but it really doesn't have anything to do with the lack of accounting. Whether or not you had experience or not, you didn't. The law requires you to do the accounting. This judge gave you a period of time to gather all the records that you possibly could. And also you were presented with the expert accountant, Brazil, or whatever her name is, her findings to go through that and pick through that. And yet you filed the declaration after a deadline, and a deadline the judge said that the court would not consider it. So how is it error when you're given a deadline to file something, and if you do not comply, the court will not consider it? You file after the deadline, the court doesn't consider it. I don't see an error here. I understand the judgment against you. I understand the stress. I understand that you care for these people. But there is no error not reviewing your declaration. That was clearly within the order, telling you.
That's on you, bud.
Get the accounting done. If you don't, and you submit anything after this deadline, the court will not consider it. Is that true?
Oh, the court gave me a deadline, but the declaration should have been considered because there was no deadline.
After the deadline, correct?
The declaration was, yes.
Okay. I don't see an error. So let's move on. Where are the other errors?
Well, the other errors are, so if someone can get a judgment against me because I missed the deadline, then I probably, I'm not going to be able to get away from this multi-million-dollar judgment against me.
Whoa. Ouch.
Hold on just a minute, please.
Yeah, you need to keep records. Very good records, especially when it's a trust fund.
I filed more I don't believe the surcharge statute permits a surcharge because I can account for all the expenditures. This is what I'm trying to say. I missed the court deadline.
You had one bite at the apple. You don't get two bites at the apple.
Well, I should have
it now. So give me another shot at this.
I should have a second bite with all of the documents I have showing all the time I expended. It's not like I put it in my pocket.
You're not being charged with a criminal theft. So if you were, then you'd get a second or third bite at the apple. But this is a trust case. Supposed to be decided by the trial court first, and we agree or disagree with the rulings.
But there's material issues of fact. I did file a declaration, which I was allowed to do to oppose the summary judgment. And in that declaration, I detail where all the money went to separate accounts, because one account was for me for trustee fees. I even out of my personal account for trustee fees, I paid Carla Werr because she demanded money right away. She had emergencies, and I just wrote a check to her, or I transferred it to electronically because she demanded so much from me, and I just went ahead and did it. And then Kenny Hawkins, I had to hire someone to take care of him in his mother's house, and I set up a checking account for him, but I had to put it in my name because he was too incompetent to go into a bank and open up a checking account. So I did that, and I transferred the money, yet I'm being charged for all this. It's not right. And as a fundamental right, this whole thing should be reversed, and let me go to Purcell and sit down with her, court appointed, and put all this out on the table. Although I believe she had all these records before the summary judgment hearing, and she just puts down she doesn't do a forensic accounting. That's number one. Number one is there's no forensic accounting. All she does is list all of the checks from the checking bank accounts, and she doesn't put down where they're going to. And sometimes, she puts down like the taxes and the Bank of America for the house for Carla and things like that for the closing. But all the other ones, like for Kenny Hawkins, she charges to me. She can charge to me for my trustee fees. That's okay. For taking care of Kenny Hawkins in that condominium so he doesn't get arrested for drugs and alcohol dealing. I mean, that's okay. But that's not okay because I spent those years in that condo almost every day making sure he didn't get arrested. I even had to go to
let me ask you this. So you could conceivably break down the expenses into two categories. One, which is funds just that went directly to some other third party, like to buy a house, but of the category of funds that went to pay you for services you rendered, the opposing counsel in its brief spoke thoroughly about whose burden it is to prove that those fees were justifiably spent out of trust funds. And you're saying that you spent time in the apartment, you did all these things, you helped them set up a bank account, but you were charging an attorney's fees rate for that. Isn't it your burden to justify that to help some a beneficiary open up a bank account that's justifiable if you spend $450 an hour?
Judge, I'm charging the same hourly rate she's always paid me for over 20 years. And the current trustee, Ms. Diamond, she charges $450 an hour. And the trust that I set up
to help one of the beneficiaries open up a checking account.
Well,
what were you doing in his apartment?
Well, one of the times I was in the mother's house, he was laying on the floor almost dead, and I had called 911. But I don't know if I charged for that. That's when he went to the emergency room.
But
they saved his life.
Fee is higher.
So things like that, whose burden is it to justify the hourly rate spent to pay the trustee himself or herself to render these services? Whose burden is it to establish that that's reasonable use of expense of trust funds?
It was never challenged. They never challenged my hourly rate, and it's always been my hourly rate. The settler set it up that way. And the trust that she signed, both trusts, gave the trustee the discretion on who to pay and how much to pay. And it was within the trustee's discretion. It's a form. I don't think it's something new, but I had discretion as trustee. And there was no one else to take my place to get all this done, to get the,
Mr.
get
Dandar,
the,
you're at 15 minutes. You can go ahead and continue.
no, I'll reserve 5. I'm sorry.
All right, sir. You may. Good morning, Mr. Elegant.
Good morning. May it please the court, I'm Tom Elegant. My partner, Amy Ferrier, is behind me in the background here. We represent Sandra Diamond, the court-appointed special.
I'm just watching the OAs.
I'm sorry, what was that?
She's watching the OAs. That's irrelevant.
Okay, okay. Anyway,
Yes, and that's because the other 2 TVs were used before COVID for,
We don't know who's talking.
I'm sorry, that's our IT person. I don't know
meeting
why.
rooms.
We can hear her. I'll see what I can do to fix that.
Okay.
Goodness, Elegant.
Okay. The rest of the trial team represents Kevin Hawkins and Carla Wurr, and they're watching by video. So I'm almost tempted to say it's apparent to me that the full panel gets it, and this should be summarily.
How about if you just hone in on the summary judgment standard?
Yeah.
Was that satisfied in this case, and was it the new rule? What are we talking about?
Absolutely the new rule, Your Honor, and that's why because the defendant had the burden, as the court's already discussed, to come forward and justify these expenses and to do it in a timely manner. When he failed to do that, the court was well within its rights to say, hey, you didn't put the evidence on, you have no admissible evidence that supports your position, and summary judgment was appropriate. I mean, he didn't do it just based on that, he did it based on the arguments and the showing of the plaintiffs. And let's talk about that for a minute. Everything that happened here is the defendant's fault. Okay, he didn't maintain the documents. He didn't produce the documents. What he did produce wasn't timely, and it was untimely, unauthenticated, and unreliable. Okay, and that's $2.6 million that he has been charged with. Now, of that, and you didn't hear anything about this. Of that, that's $1.5 million that he paid himself, paid to himself or his firm. And then when he was asked if he reported that to the IRS, he took the Fifth Amendment. Okay, we don't have to show he misappropriated money. When the trustee fails to account, it is charged to him. He had the sole duty and burden to account for all these transactions. It's not the job of somebody else, Ms. Purcell or Ms. Diamond, to ferret that out. And by the way, that's why we filed the Supplemental Authority of Black's Law Dictionary on forensic accounting. This was a forensic accounting. Forensic accounting is just the application of accountancy principles to monetary issues that arise in courts. That's what this was. To the extent he wants to complain, it could have been better. That's his fault. He didn't provide the documents. Okay.
Paid himself
and
1.5
in fact,
million.
I mean, if they hadn't ferreted out, which is not their job, but they hadn't figured out the Soho thing, there'd have been another $600,000. So he got a benefit from that because he admit there's really a simple answer to this appeal. You heard him say that the relief he wants, and it's the same thing he says in his brief, is to have Purcell go back and work with him to do an accounting. Okay, that ship has sailed.
Well, their argument, according to the attorney below, went to damages, not to liability or culpability, correct?
Exactly, Your Honor. That was the next point I was going to make. His counsel, this is page 69 of the transcript from December 2022, it's in our appendix at page 69, admitted the only question is the amount. Okay, he has not asked for this court to visit the amount. He has not said, oh, well, here, this was too much. This is a specific thing. I proved this. I had admissible evidence to show this was too much. He hasn't done that. The only thing he asked for is to go back and start again, which he's not entitled to.
That's not relief we generally grant.
That's right. That's correct. I mean, that ship has sailed. And because that's all he asked for. He hasn't asked for anything else. And the simple answer, he hasn't asked for the other relief, so it should be affirmed.
Well, I mean, to be honest, it sounds like there may be a morality issue. Maybe there's something done wrong, but that's not the standard of review that we look at.
If you're saying, did the trustee here do
Well,
something?
he claims he's at the condo every day. He helped his son. His son had drug issues. He ran to Mexico, kept him out of jail. Well, he did a lot other than misapply the rules.
Yeah, and, Your Honor, you look at those time records, they go all the way back to 2009, where he's testified under oath the trust didn't have any assets, the 2009 trust. Now he tries to change that at different times. So it depends on which testimony or statement you look at. But the trust required a written direction for a distribution during Peggy's life. So all this money that was spent then wouldn't have been valid anyway. And again, $1.5 million to himself, won't say if he reported to the IRS. What does that say? Okay, on the house, he says, "Oh, I paid $525,000 for a house." Well, in his amended appendix at 467, there's a document that shows if you believe it, it's untimely, it's unauthenticated, but if you believe it, it shows $525 paid in 2018. In Ms. Prezell's and Diamond's, I think it actually was Diamond's analysis, the property appraiser has that property at $377,000 in 2020. Property's not going down in Pinellas County between 2018 and 2020. And anybody who's familiar is going to know they assess those at near full value. So there's something funky going on there. Had those documents been produced timely, that could have been investigated, but they weren't. Again, untimely can't be considered.
But does it show that the trust bought the house?
If they are accurate, which they have not been authenticated. They're not. There's things he stuck in the record, and too late, way after the fact. So that's the problem there. And again, the point is he did not timely account for them within the deadline when he needed to, so he does not get credit for that.
Elliot's making the argument against the defendant here.
He also, you heard something about charging her this rate. He also testified he never charged her while she was alive. So, again, it's all over the place.
So how did he get to the 1.5 million in billables?
Never billed her during his life. That's at page 957 of the record and a few pages after. I guess at this point I would ask, does the court have any questions? We would ask you to affirm.
Oh, thank you.
Thank you. Mr. Dandar, you have 4.5 minutes.
Your Honor, could I take a 2-minute break?
It's a comfort break?
Yes, please.
Okay.
Thank you.
In recess, 2 minutes.
Run for the border.
On the clock.
We're going to got the Florida District Second Court of Appeal. Remote oral arguments. Give them 2 minutes. And here you go. Comes back. Chief judges are here. There we go.
All right, we're back in session. Mr. Dandar, you have, what did I say?
5 minutes.
I think your mic is muted. It's okay.
Is it? Oh, it is?
5 minutes,
4.5 minutes, sir. Go ahead.
Okay. Judge, in our reply brief, we filed what was sealed by the clerk of the court at we don't know why it was sealed. And those records are my banking records, which Purcell had. And those banking records show how all of the funds were distributed by me as trustee to the beneficiaries and for the beneficiaries. And the judge refused to look at all those because it was sealed, I guess. And he refused to consider my declaration. This is a summary judgment. We should have a trial. There should be a trial on the merits, not a summary judgment.
Isn't your argument, I use the forms that the Florida Bar promulgates for trust, and therefore that should be good enough? Is that the gist of your argument?
No, I do not believe I said that. I used the forms from the Florida bar. I don't remember saying
Well, I
that.
don't know where the forms came from. You said you used, quote, the forms.
I'm
We
not
can
sure
move
why.
on.
All
I don't
right.
think he used any forms.
And Purcell had all the banking records. That's how she made her simple list of what the checks were written. And she guessed at where they went. And guessing was not good enough. She wasn't forensic accounting at that time. She was just doing a list of checks. And my appendix A and B shows, after we got the clerks unsealed the records with consent of opposing counsel, the appendix shows that these are all checks written by me for the benefit of the
And did you
beneficiaries.
ever provide an accounting before the lawsuit was filed? Of any
Before
sort?
the lawsuit was filed.
When did you file your first accounting other than the preliminary one in 2009, let's say?
Never did.
I filed what I thought was an accounting in opposing the summary judgment with my sworn at declaration, and the court didn't look at it.
Because it was untimely.
It was untimely, and that's not. I don't think justice should play that way, and I think that may create. It's a summary judgment. It's not a trial. It's different if you were in a trial and didn't produce evidence that you had. But the accounting should have been considered by the court on a motion for summary judgment. There's issues of material fact. That's the standard. And then when I filed my motion for fraud on the court just summarily denied that as well. And it's obvious in what I filed exhibits, I'm being charged for an account of Peggy Hawkins while she is alive in over $300,000, has nothing to do with the trust. And yet I'm being charged for that under the Purcell affidavit. And that is a fraud on the court because there's nothing there that has anything to do with me as the trustee. Also, again, I'm being charged for the Carla Ware's house, and she's the plaintiff, and she knows darn well I bought her that house at her
It sounds
request.
like an argument. I know, but it sounds like you're making an argument all over again that you made below.
I'm sorry.
I don't want to cut into your time. You got a couple minutes left.
But all of this was in the file of the lower court of all these checks that I wrote from my checking accounts to and for the benefit of the beneficiaries, and it was sealed, and the judge never looked at it. So these are issues of material fact. And now that it's opened, we go back down and we'll get the judge now to look at all of this. And I think that would be the justice if he indeed is ordered to look at it, set aside the judgment, and let's proceed to a trial. Because I can document everything that I did, and I documented it in the declaration with the attachments, like 88 pages of attachments. And I also documented it in the getting the court to unseal the files. And those are the records that the court should have looked at but didn't look at. And it shows that I didn't take any money. I spent the money appropriately on the beneficiaries and spent the money on my time. In fact, I discounted a great deal of my time.
I spent it on my time.
Right at the end of your time.
All right. I thank you so much.
Thank you very much. Thank you both. We appreciate it. That concludes
the hearing. I went to the Florida bar page, and there is a Kenan George Dander who looks a little bit different. By the same name, member, good standing, eligible to practice law in Florida. Not sure if it's the same guy because his website's not working. So, let's see. Mathis, I actually watched that one before. I'm not sure if we've ever watched it on the channel. I got the feeling we watched it one time before. But if we did, please let me know. All right, let's see. There is a trial in Iowa that I think is just completed jury selection, right? Might be one we could jump to. But let me... back-to-back Iowa trials. That's crazy. Type. We'll see if this one comes in. We'll wait and listen, see if we get any openings on that one. No outcome. No, that's just the outcomes are released by written, like a written statement. So I don't know how that one ended. I'll need Mathis or somebody to do the research on that. Bad thing on appeal arguments is we don't get the result. We just get the spice, and that's it. I saw Valhalla Awaits in here earlier. I saw Kurt as well. Welcome, fellow YouTubers. There's Valhalla Awaits. He's going to swallow a freedom seed real quick. Valhalla Awaits. My Legos arrived, and I'm second-guessing my decision because there are a lot of pieces. And by a lot of pieces, I mean in the 4 digits of pieces. And I'm not an experienced master builder. And I also don't have all night to build. So I'm debating getting a fallback, like a safety net. But that'll take a while. Yeah. I don't have that much to talk about. We'll run out of things to say, and I'll still be building. So. Yeah, we'll see. Anyway, I've at least got a set. So the box arrived and it weighed like 15 pounds, but apparently it was all packaging and box. So please tell RA how to say Lego. I say it just like the flower. You know what a sago lily is? S-E-G-O, sago lily. It's a Lego. Mel says he says it right, like I do. It is going to be a surprise. The set I did all my research. I went back through Valhalla Awaits and tried to look at all the different people who have been on, and I couldn't find anyone else who has done this set. Probably for good reason. Now that I see the set, so it's gonna be rough. The Iowa trial, that's I think they just got a jury seat. I think we're waiting for openings. Have not happened yet. I'll see if we get anything on that one. Look in mod chat. It's interesting, Josh. Same lawyers shows up on a different filing. I'm going to skip that one, though. I'm not going to read that. Do you have an organizer box with dividers that helps when building Legos? No, I was just going to dump everything on my desk. The idea was I was going to use the desk here and maybe push some of the equipment off. I think I can give it a shove and it can sort of like hide a little ways. It can just scoot away and then maybe build right here. The trial that should be starting here in Iowa just in a minute is Christopher Behal. I'm probably saying that wrong. I think he was arrested after crashing in a drunk driving incident. Not sure if he hit anyone else. But he crashed, was taken to the hospital, and made a statement, something to the effect of, I think you should probably do a welfare check on my girlfriend because I've been having visions of violence. And yeah, she was dead. Stabby, 31 times. Pretty bad. So Selena's like, oh, that sounds good. Sounds juicy. We're waiting to see if they start with opening statements today. Put down a platform so it's easier to move when done. I will be building on a platform. Otherwise, I will knock everything off my desk. I have to have something stuck somewhere. Pre-building is considered cheating. Yeah, I have not even opened the package. I'm not above cheating, but I have not. Misconduct says, as a European, please stop RA from saying Lego properly and make him say it incorrectly and let him say it incorrectly. Oh, wait. Stop him from saying Lego and let him say it incorrectly. Okay, since nothing's happening here, we might jump down to Judge Boyd, who is, I think, still holding court right now. They're in San Antonio. We haven't been there in quite a while. Judge Stephanie Boyd.
It was 8 p.m. on this day. You didn't come in at 8, you came at 9. And then I told you again, it was 8 p.m. and you come in at 9 again. And so maybe she would say, hey, you're not allowed out anymore. Now, as a side note, I never broke curfew, but that's what I mean by things you consider in punishment. But mind you, that's not something that my mom would consider if I didn't break curfew. So she wouldn't immediately say, oh, your punishment is going to be you're not allowed to go out before she even determines if I broke curfew or not. So in any case where someone may or may not have prior convictions, you're supposed to concentrate on whether or not they're guilty of what they've been accused of. Does everyone understand?
Yes.
Because there are sometimes you may have somebody who's accused of something when they're a teenager. Maybe they went through rough patches and then they've got their self together and then they get accused of something else, maybe 10, 15, 20 years later. And it's like, hey, I didn't do this. So is there anyone here who cannot consider and focus just on whether somebody is guilty or not guilty first, and then look at punishment second if you were to find them guilty? Is there anyone who's unable to do that? All right, 41.
41 wants off the
46.
jury.
All right, thank you. Now, the next thing I want to talk to you about is the English language. I love English. I love languages. I'm originally from Louisiana. So, of course, when my friend suggested we take Spanish, I was like, we're not taking Spanish. I'm not going to take Spanish. I'm not going to need it. I'm going to be retired at 21. I'm going to be living my life in Paris, and I'm in Louisiana. It's French. So, of course, unbeknownst to me, I was going to end up in Texas, and I should have taken Spanish. So is there anyone here, English is not your first language? Please raise your card. All right, 29, 44, 51, and 63. 29, what's your first language?
Spanish.
All right, have you been able to understand everything? Thank you.
Yes.
44, you may be seated. 44, what's your first language? Have you been able to understand everything? 51, what's your first language? Have you been able to understand everything?
Yeah.
63, what's your first language?
Spanish.
Have you been able to understand everything?
Yes.
All right, thank you. That's odd. Usually we have a lot of languages thrown in. There's no Philippines in here. Usually we have at least 22. What's your language?
We speak Filipino, but we grew up speaking English in the Philippines. Because our medium of instruction.
All right, thank you. And have you been able to understand everything?
Yeah.
Thank you. I knew someone from the Philippines was going to be here. All right, before I turn it over to the parties, I'm going to tell you 2 stories, and I have one more question. Other than meeting downstairs in the jury room and standing in the hallway, does anyone know anyone on the panel?
You know each other.
All right. All right. See, if one person, 3 people have raised their cards, so all 3 of you should know each other. 22, 34, 63, 66. All right, juror number 22, who do you know?
Mr. James.
All right, that's 66. How do you guys know each other?
We attend the same church.
Oh, okay, awesome. Thank you.
We go to church together.
Number 34, who do you know?
Love James.
Oh my gosh. You're popular.
Mr. James.
Thank you. How do you know each other?
For UIW.
All right, thank you. Number 63?
Glenn James.
Oh my gosh. All right. You are popular. Everybody knows you.
Mr. James,
And
do you
I'm
know
assuming
anyone else?
You know all of them.
No, I don't. I just know Glenn through, we used to train together.
Oh, awesome. And where were you all training?
With the same coach for triathlon.
All right. Okay, awesome. All right, so I'm going to tell you all 2 stories. They're both true. The first story I'm going to tell you about is my uncle. And I always tell jurors the story because I want people to know that jury duty is an inconvenience. It's not a sacrifice. Your country only asks 2 things of you. They ask that 1, you pay your taxes, and 2, you serve on a jury. That's it. Raise your card if you've ever served and actually been on a jury trial where you were a juror. All right, so everyone look around. That is not even a third of the people here. You can lower them. So the country isn't even calling you up once a month or once every 3 months to serve. It's just really once in a blue moon when you think about it. And so I always tell people, I see people 4th of July, Memorial Day, they're waving flags, but I'm like, do you try to get out of jury duty? Don't do that. Because in order for us to have jury trials, we need jurors. So my uncle grew up in a small town called Grand Cane, Louisiana. Super intelligent, my grandmother's firstborn. Teachers would just skip him to the next grade because they tell my grandmother, they'd say, Miss Lane, we taught him everything we can teach him. And so they'd move him to the next grade. Now, when his brother and his sisters came behind him to go to school, they didn't like that much because all the teachers knew everybody and they would say, we've seen your brother, we're expecting a lot out of you all. You all better be super intelligent. So my uncle graduates, and when he graduates, the Vietnam War breaks out. And he goes to my grandmother and he asks my grandmother to sign for him so he can go because he said, you know, based upon what's happening, civil rights, everything, there's no way I can improve my lot in life, here. So I'm going to join the military. So my grandmother signed for him to go in the military. And I consider that a sacrifice because that's our firstborn. And when you think about it, nobody in the United States, my grandmother would always tell us this story when she was alive. Nobody in the United States really knew where Vietnam was. Nobody knew what it was about. My grandmother only had a 6th grade education, but she was super intelligent. She taught me how to read and write, and she would babysit while my mom was at work. But they only had 3 stations, ABC, NBC, and CBS. And NBC, I don't know if you would really call that a station because the weather had to be perfect. Otherwise, you were not going to get any picture. And then the thing about those 3 stations is young people, there wasn't this 24/7, 7 days a week thing. Programming would end and they played the national anthem. When they got advanced, the flag would just blow in the wind and you just wait for the next day for it to begin again. My grandmother did have a phone, but it didn't have the numbers on it, young people. I know you don't know what a rotary is or touch tone, but it wasn't a rotary, it wasn't a touch tone. You pick it up, when you pick it up, the operator would answer and you would tell them what you wanted. That's why they have songs like Beechwood 4, 5, 7, 8, 9. So when my uncle went off, all she could do was write him letters. There wasn't a computer, there wasn't an email. So she just knew his number. She wrote a letter and wait for it to come back. And she quickly learned that You don't want the military knocking at your door, anybody official, because that wasn't good news. So I tell people that's a sacrifice. With jury duty, people are only asking for this much of your time. It's not a sacrifice. It's an inconvenience. The other story I'm going to tell you is about my friend. She and I went to law school together. She was called up for jury duty. She practiced on the civil side, and usually, no shade to civil attorneys, but they're not in court every day usually. And so she said, hey, let's meet for lunch. I have jury duty. I'm like, great. So we're eating, we're having fun. I asked her, how's jury duty going? She's like, it's going fantastic and fabulous. Now that I'm judge, I'm like, how can it be fantastic and fabulous? I wasn't your judge. What are you talking about? So I said, what do you mean by that? She's like, oh, I'm not going to be selected. It's like law school. I'm in the back. I got my head down. And so I started laughing, and she wanted to know what's so funny. And I said, you and I are going to get to have lunch all week. And so the easiest way to be on this jury, other than raising your card and saying, please select me, is to be quiet. And I tell you all that story because both the state and the defense are going to get 30 minutes to get to know you. That's all they get. They don't get the chance to go out with dinner with you and hear your opinions. It's just 30 minutes each side. Does everyone understand? All right. Does anyone need a break? All right. And then Miss Abrams, the probation, you're right there. So here's the thing. Miss Abrams is here. She's a probation officer in this court. She's not involved in this case. You're going to see people who come through this door. It's just for me to sign document. It's not about this case. The person sitting here is a student in my class. They're just here to observe. And when people come through that door, they're coming through that door because they don't see the sign that says, we're in jury trial. Please do not come through that door. And Miss Abrams always tells me, Judge, you didn't tell them what happened to your uncle. She's like, people want to know, did he make it back? So my uncle made it back, but he's since passed. So with that being said, I am going to turn it over to the state. Are you ready to proceed, state?
Yes, Judge.
Do you need?
Give her the mic.
Sure.
If we can't hear, we're going to bail.
All right, good afternoon, everyone. My name is Megan Galloway, and I have a confession to make to all of you. So early this morning when I was on my way to work, it's no secret that there's a lot of construction that's going on downtown right now. And so when I was turning on Cesar Chavez, merges into one lane, and I was in a hurry this morning with the rain. It was taking me longer than I anticipated to get to work. You can't hear me? Okay. So this morning it was taking me longer than I anticipated to get to work. And there was a car that probably doesn't travel downtown as much as I do. And they had to merge at the last minute. And I go, oh my goodness, any other morning I would let you merge, but not this morning. And so I'm confessing that to you all because if you see me and you say, hey, that's that jerk that did not let me merge this morning, speak now or forever hold your peace. Okay. So as the judge said, we're going to talk about, I know you all are probably feeling like
there's not going to be a picture for this part.
Call on me. But it is important that you guys respond to me when I, am asking you questions because the easiest way to end up on the jury is to remain silent. So, if you're not talking, that's probably what you're going to look like at the end of my 30 minutes and defense's 30 minutes and panel. Look at how happy we look. So I want to talk to you all about what the purpose of jury selection is. It's like the judge said, we're only going to talk about the law that applies. We cannot speak about the facts. But it's to learn about you all and find 12 fair and impartial jurors that can render a verdict according to the law and the evidence, okay? And so who can tell me who that is up there? Willie Nelson, okay, and what does Willie Nelson love? Marijuana, right? And so it's not a secret, right? It's really vocal about this. So if Willie Nelson was chosen to sit on a misdemeanor possession of marijuana case, what do you think that his verdict would be in the case?
Not guilty.
Not guilty, right? And that's because he fundamentally disagrees with that law. And that's fine, but that's just something that we need to know. And so I'm going to refer to something called the Willie Rule. And what I mean by the Willie Rule is, do you understand the law? Do you agree or disagree with it? And can you follow it ultimately? Okay? Like I said, we're just looking for fair and impartial jurors. That means that you're going to base your decision solely on the evidence in the law that's given to you from the court. Okay? And so I have a rule in my jury selection, and that is no waffling. Okay, because a lot of times we get jurors in here and I ask them a yes or no question, and they're kind of like the little engine that could. And they're like, I think I can. I think I can. And I'm sorry to inform you, but in this setting, I think I can is not good enough. Okay, so I need you to commit to your answer, yes or no. Everyone got that?
Yes.
Okay. So the judge talked about this earlier. It's a burden of proof that lays solely on the state, and that is beyond a reasonable doubt. Like she said, there is no definition for that, but it doesn't mean 100%. It doesn't mean beyond a shadow of all doubt. And it goes to the elements of the offense, okay? And so, who can tell me what happened in this photo? Well, okay, who's come home to this by a show of hands or cards? Okay, juror number, what's your number? 5, okay. Can you please tell me what you think happened here? Trash. The dog got into the trash, right? And so how can we tell that, right? By looking at the facts and circumstances that are depicted in the photo, right? And so, you know, he's there, he's looking a little guilty. The trash is surrounding him. And so what I like to think about, and when I talk about the burden of proof, is what is reasonable and what's possible. So in this fact scenario, is it possible that someone maybe broke into the home, just scattered the trash on the floor, but there's no signs of forced entry? There was nothing taken out of the home, and this person just wanted to go in the home and dump the trash out and run out? It's possible, but that's not reasonable, right? And that is not what the evidence suggests, okay? Does anybody have any questions about that? So knowing that standard and that hypothetical that I just gave you all, is there anyone here that says, you know what, that's not good enough for me? In this case, I would require the state to prove their case 100%, beyond a shadow of doubt.
They're not going to show the jury during the selection.
Anybody? Number 46. Okay, anyone else? Juror number 23 and juror number 30.
46 is
Juror
trying
number
to get out of service.
Okay, and so you all are saying that you understand, right, the burden is beyond a reasonable doubt, that you would hold the state to a higher standard. Is that correct, juror number 1? The 2 that had cards over here, is that correct? What's your number? 23. Okay, thank you. All right, is that correct, juror number 30? Okay. Juror number 46, is your card raised? Okay, so that you would hold the state to higher burden. Okay. Now I have this question that I want you all to
46
answer,
is out.
and it's, what is your opinion of the criminal justice system? So you have 4 choices here. The first one being you think it's terrible and it takes away the rights of citizens. Choice number 2 is you think it's concerning because it interferes with the rights of citizens. Choice 3 is, did I say choice 30? Choice 2. Okay, then choice 3 is helpful. You think it looks out for citizens. And choice 4 is beneficial. It protects us from the harmful actions of others. So if you are with choice 1 and you think that the criminal justice system is terrible, would you please raise your card? Juror number 21.
21
Okay,
months. Yeah.
and is that based like on a personal experience? Okay, and would you be able to set that feeling or personal experience aside and render a fair verdict? No. Thank you so much.
He's out.
If you are choice number 2, would you please raise your card? Do you think it's concerning and interferes with the rights of others? Okay. Jurors 1, 2, 4, 20, 30, 36, 41, 57, 58, 65, 71, 73, and 74. All right, thank you so much. Juror 3. Okay. Not 2. Juror 2, did you by chance have your first race? Okay. So who's with choice number 3 you think it's helpful and looks out for citizens? Okay. All right, juror 2, 9, 10 through 12, 14, 6. Okay, if I call your number, you can put your card down. Thank you. 15 through 19, 22 through 25, 27, 28, 31, 33, 35, 39, 40, 42, 44, 46, 47, 49, 50, 51, 54, 56, 59, 60, 61, 67, 70. Thank you. And then choice number 4, please. Is 5, 7, 8, 13, 26, 29, 34.
We have to pause this. We have customer support calling right now.
43,
Hang on.
45.
Hello? Hello? Hello?
Yes, good afternoon. This is Alexia and I'm calling you from Expired Accounts Department. How are you doing?
Good.
That's great to hear. So by the way, am I speaking to Dwayne?
Mm-hmm.
All right, so sir, I'm calling you regarding to a large amount of a travel credit that you have in file. And I see the activation fees recovered. You just never booked dates in travel. You don't want to see you lose the credit or the vacations themselves. And I know you still see yourself traveling in the future, right?
I do.
Oh, that's perfect. Yes, so we are starting you off with the 4 days, 3 nights resort stay in Vegas, either on or off the strip. And also you have 4 days, 3 nights resort stay in Orlando, which is minutes from all the theme parks. And also you have an 8 day, 7 night all-inclusive flex cruise with Carnival, Royal Caribbean or Norwegian Cruise Lines. And also the good thing in this package is fully customizable, so you can pick and choose your own destination. And now, I do see here that the only thing that you're gonna be responsible in this package is only the booking and the processing fees. And I know that I can do something really special for you, sir. So can you please give me a 1 moment to pull up your full account?
Okay.
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 All right. So yeah, just stay in the line for a moment.
Hello, Dwayne.
Hello.
Hi, good afternoon. Thank you so much for holding. My name is Ali, one of the account directors with Your Choice Getaways. How are you today?
I'm doing great.
That's good to hear. And by the way, before we proceed, did you happen to have any questions about the vacation so far?
About the specific vacations,
Uh-huh.
I've got some about, cabins and things like that. Is that, are you the person I talked to about that?
Say that one more time.
Like I'd like to know about the cabins on the cruise line. I've had problems before where the windows were I was on too high of a floor, and so when the boat was rocking back and forth, because there was a huge storm, I just got sick, and I threw up all over the bed, and I guess everyone did, because it took like 4 hours for them to come clean it up. So if I go on a cruise, I need like a lower level so that if it does get in a storm, it doesn't shake as much.
Yeah, so it is an inside cabin accommodation. Now,
Is that an extra
you
fee?
could either. No, there is no extra fee for that one.
Okay.
So aside from your cruise, Dwayne, you do have a total of 4 trips in the package. Now there is 3 land trips and 1 for the cruise, and all of the trips is non-expirable, so you can use it anytime. And aside from that, it is also transferable, so you can transfer any part of the package to one of your family members, friends, loved ones, and they just have to be the age of 25. No, all of.
Do they have to
Mhm.
be alive? Like I've got a friend who passed, and I carry his remains around with me. Could I bring him as a guest? Could he be my guest? apparently, ashes are not allowed. No ashes allowed. She hung up on me. So, all right, I tried. I try to mix a little bit of truth in with the story for those. But can you transfer to chat? It's not expirable, but try to find us. Yeah. 2 truths and a lie. Yes, I say that having just lost a couple friends in this past month, and I just found out they've asked me. My last friend who passed away on Sunday. His family asked me to live stream the funeral for family members who will be too far away. So I'm going to be doing that for them on Saturday. What's happening Saturday? Is anything else happening Saturday? Oh, it's going to be Saturday during the day. Because at night, Valhalla waits. We're going to be, Legos. Valhalla waits like, yeah, that's our day. That's our day. Well, the funeral's in the morning, and then we'll be available for the live stream in the evening. So, one day you got to ask them if they want to hear a song about why you can't go back to Vegas. Oh, I should play them a song. Oh my goodness, that would be great. They would hang up in a heartbeat, though. I don't think they'd understand it. But good. All right, I'm not sure. Do we want to go back and watch more of jury selection? There's not a lot to see in jury selection. I always like the process, but it's hard to run a YouTube channel with audio only. If we were radio only, that might be better. But opening statements have not started yet in the trial in Iowa yet. The Visions of Violence trial. They say I'm addicted to crime. Yeah, that's a good one. Valhalla waits. I'm so excited about Saturday night. I cannot begin to tell you. But I have things I'm doing early Sunday morning, so I need to be done before. I mean, if this goes 3 hours, I'm going to fall asleep. Yeah, so we need. I need to build quickly. That's what I need to do. So anyway, I was out for much yesterday and today. Did the man get a retrial? Martha, the answer to that is we don't know yet. It's going to be about at least a month before the judge issues a ruling, because it's both sides have a month to submit their final 5-page, statement filing to the court, which she will consider before she makes a ruling. Need like 400 to 500 pieces. Well, I went bigger than that. I went big. I might find another option. Okay. Especially because I've Valhalla waits. I cannot remember a single time where I have built a Lego kit fully, other than like one of those that come in a little plastic bag, just like a little character in a motorcycle or something. I don't know if I ever have. I've always played with what I would call secondhand Legos, where my siblings got them first, and then they were mixed in, and pieces were lost and stepped on and thrown away and thrown down to the drain and everything else. And so I've always just done sort of like free building. Are you left-handed? I am. I'm actually carrying. I wrote a check today for my my power and water bill for my town, and it cost me just about $1,000. So I wrote the check with the pen that Rob made me. But yes, I'm left-handed. I was watching the Swan Boat House trial, which started yesterday, says Linda. That's the crash one, right? Yeah, that's a tough one. My daughter built an entire Lego city. Fun fact, I've never built anything Lego. I'm so excited. I think I'm pretty sure, I'm like 99% sure that once I build one Lego set, I want to incorporate the same sort of thing into my live streams. I'm just like, look, this is the best idea ever. We need to do more of these. With disappearing ink, no. Please say leg O. Okay, leg O. Got it. Leg O. Lego Titanic, 9,090 pieces. I was thinking the Eiffel Tower would be a good one. That's a lot. Hope it's not a month's worth. That was actually 2 months because the town on our bill, we normally pay with an automatic payment with a credit card, which we pay all of our bills on a credit card, and then we get points on the credit card, and that gives us some cash back. Well, the town got wise on that. Apparently the fee is too high, and they just decided to stop taking the credit card we used. Not that there was ever a problem. It always paid on time. They just stopped accepting that brand of credit card. And so then they called us like the day before it was due and said, oh, by the way, it didn't go through last month because we don't accept your card anymore. And now the next month's due as well. And through a comedy of errors, Mrs. R.A. ran a check down to the city offices. And she found on accident my old checking account from when I was a teenager, which I still have unused checkbooks for on file with our financial documents. And she wrote the check from that account, which, guess what? The account is open, but it just sits there with nothing in it. So you can guess what happened to that check, which caused, the rebound, boing. And so I get a notice on my door today, an orange notice on my door saying, we're going to shut off your bill because it's been, I'm like, oh. So I ran down there and on lunch before I went to the post office and paid the bill on the right account. So now it's taken care of. But your check kiting now. Anyway, passing bad checks, naughty, naughty. The last time I bounced a check was, I think I was 16. It was on that same account, mind you. That same account I bounced a check on. And I didn't realize that when I put money in the bank account, if I put it in savings and then I spent it, that savings and checkings just weren't like the same thing. I just deposited it and it went in savings and it should have gone in checking. So I wrote a check and it bounced and I was mortified. But was it when you were trying to pay for your Columbia House cassette tapes? No. Hey, little RA. This is all going on with permanent record. It should. It's funny because Mrs. RA and I, we don't do debt, right? We don't do debt. That's our thing. I don't know. Some people say follow the Dave Ramsey principle and everything. We're so frugal we won't even pay for Dave Ramsey's program, and so it's been awesome. I mean, it's always hard in the moment because we've never had a cable TV bill because we just don't have cable TV, and we don't do a lot of things that I can count on one hand the number of times my family's gone on vacation, and I can use 2 fingers to do it. We're very, very frugal, and so believe it or not, our credit scores are phenomenal. They're really good because we don't have any. But anyway, cable's overrated. I'm not sure why we're talking about that. Just got an update as of 4 minutes ago. Law Crime Trials is still working on the feed. Thanks, Josh. That's on the other case. I went shopping, wrote checks, and added to my checkbook instead of subtracting. My mom was impressed. I didn't notice every time I bought something I had more money. Oh, man, that catches you eventually. I'll catch you eventually. I have to say that my financial frugality came at the insistence of Mrs. R.A. And I'm terrible with money myself. Mrs. R.A. is fantastic with money. She's actually gone to school for accounting and all that. She understands the numbers in a big way. So I've learned a little bit from her. April, we get fresh $100 bills. What? Melanie, is that a real thing? Are they going to be colored like Canada and Australia, or are we still going with the greenback? Okay. Let's see. Let's jump down to McBurney really quickly and see how he's doing in his court. We haven't been there in a long time. I hate his audio, but let's try it.
Judge, the state will remove the gainful employment requirement, although, I mean, to be completely frank, I don't think we discussed it. I think it's part of the general conditions, but I will remove that since we didn't discuss it specifically, although the state will note for the record that that is probably the least obtrusive of the requirements.
Okay. What's the concern about? Is there a disability or just no one agreed to be working?
He's getting a settlement and he might not need to work.
Okay. Got it.
Again.
Oh,
it's a big settlement.
Well, cool.
Yeah. Use it wisely. Okay.
So Judge, counts 2 and 3 are going to be concurrent with count 1. Count 4, the state would note as a operation of law, would merge in to count 1. The visible injuries as part of the strangulation.
Whoa.
And then both the case that was on the calendar, 23, 19, 17, 19, and 25 SC 13150, those are both 12-month sentences to run concurrent with count 1.
Is the case, the 23 SC case, it's a misdemeanor? Or is it a felony because there was a prior?
It's a felony, but pursuant to negotiation, we're running it together.
You're welcome to run it together, but wouldn't the sentence be 1 year? I know this sounds like
I've got to bail on this
list technicality, but
okay. Let me tell you why I'm bailing. I love Judge McBurney. I want so badly to go in there and move his microphone to a place where he cannot get his mouth close enough to it. He thinks that the closer you are, the better it is. Like, eat the microphone. And the gain is too high. It's clipped so badly, and the audio file in me revolts. I'm not in the fire zone. The fires are at least 100 miles away from me right now. But tomorrow we are in the weather zone, and that weather might push some fires. Hopefully not 100 miles, but yeah, hopefully we don't have any problems that way. Let's see. Friends are in Raleigh. That is awesome. Miss R.A. is amazing. All the organizing and finances. I need her, says Christy G. She does it for us, but she does a little organizing for other people. I tell you what, Mrs. R.A. has developed an ability to do art. Like she's taught herself art in, I don't know, the last year. And she's fantastic at it. Like decorating journal books where you just do little arts and drawing and stickers and lines. And she started off rough. I'd say rough. Anyone who starts off rough, she was way beyond me. I can draw stick figures, and even them not very well. She started off, and then she's now phenomenal. And her journals look absolutely stunning. I think she should do it on her channel and just talk while she does that. Okay. What's this one? Sorry, mods are talking. Anyway, all right. I think she needs to do it. We'll figure it out. Okay, here's. I think this is what I'm going to do this afternoon. It's quiet. It's 5:00. It's nearly the end of the day. We need to have. We're going to end for today. I'm going to run to the store and get a backup Lego set. And I'll probably take my kids with me to choose. My daughter's like, yeah. We're going to go and get a backup Lego set because the one I got with thousands of pieces is probably not going to be good for the live stream. No. But you never ever say the Q word. What Q word? What did I say? A Q? Was quit for the day? Is that it? I said Q for the day. It would be good for 2 live streams. I don't know if I have enough stories to tell you to last one. Valhalla waits. I'm super excited about it though. I've watching the other ones, going back and seeing some of my some of the people I really know and respect throughout the Law Tube and adjacent, being on there and getting to see them in a little different way than you normally see them. It's been fantastic. I cannot wait. I can't wait. Alternative to shush. You said quiet. What's the quiet word? You're gonna have to tell me in mod chat. I don't know what I did. What did I do wrong? I don't know what I did wrong. Now all heck's gonna break loose. You said it's too quiet around here. That's a jinx. Oh. All right. I did say the quiet part out loud. I'm gonna hurry and get out of here before everything breaks loose then. How about that? We're hoping to have a trial tomorrow. If things work out. If things work out. We're gonna try. Please go live in Walmart again. It's gonna have to be the scary Walmart. Maybe we can go to the other one. 10th Street. We'll see. Iowa case next. I don't know. They're having a lot of issues in that case. A lot of issues with access. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again tomorrow morning. New trial upcoming. I think I'm going to go to Hooker Road. I'm going to chance it. I don't know. I'm pretty sure my wife won't let me take the kids there. That's a dangerous place. All right, thank you, everyone. Thanks to all of you in chat. Thanks to our wonderful mods for the great work they do day in and day out. Thank you, thank you, thank you. You're grounded. Go to your homework assignment. Back up Lego kit. Yes. I'm grounded. All right, have a good night. You guys are wonderful. Know that I love you. You're amazing. You're all wonderful. Have a fantastic day. We will see you in the morning. Bye-bye.